Anticipatory bail. This is tired of matter. Maybe taken up tomorrow.
Tomorrow night?
Last, your lordship, last occasion also directed. It has not listed.
Not
यहाँ पर आगे 2000 matter पढ़ाइलानी serially.
देखिए सेमती कौन ये तो exceptional urgency कौन ଅଛି?
Police is searching for arrest. He is a driver of the vehicle, my lord.
You have been able to.
नहीं मैंने चाहिए.
सुनो ना मैं कौन कहूँगी? मैं कहला को मझे कहीं कहूँ ठीक है सुनो सर आप कहला को मैं सुनुची आगे. मैं कहला को अंतर ठीक है सुनो. सेती कटसी थाओ. आगे if you have managed to dodge the police so far, and I am sure you can dodge the police for one more week. So it's not that urgent that it will come tomorrow. Do you see the day after so many matters are coming? There are different.
जानी चीजें खाली means फाइल टा पट्टा है लाइए. तो तभी
देखिए.
Tired of matter man.
Pardon to make a mention, my lord.
Yes, item.
This item has been fixed for 15.
Which item?
PLAPL 440 of 2000.
Yes.
For that matter. All the co-accused person has been released on bail, lordship. By your lordship.
All right, give the
Lordship.
Bail is tied up.
If you note of submission.
Well, one RSA file for education case, state the education case for jurisdiction.
stay of
Education case.
good.
Pardon to mention, my lord, I am on VC, my lord.
Yes.
RSA 569 of 23, my lord.
Yes.
The writ of possession is issued, my lord. 569 of 23, it's a money suit. My father had taken loan. Now the LRs are their house is getting attached.
File a memo.
My lord, I'm in course of day, my lord.
Yes.
Delhi item number 1, fresh admission.
May I please, your lordship?
Yes.
This is a second appeal to confirming against the confirming judgment, but the
Confirming judgment.
but the issue involved in this relate to applicability of a repealing act for claiming partition by a scheduled tribe woman. My lord. Before placing the undisputedly, both the courts concurring that this property is a joint family property. Genealogy.
Anna. Can I think over online?
Genealogy. Nimai is the common ancestor, and Nimai died living with one son Bahadur, and Bahadur has died living with the Salma and two sons Nimai and Lakhdar. The son, grandson Nimai died in the year 1949. Living man is Uddha Dugi, and Dugi is the plaintiff before the trial court claiming partition in the year 2014.
Who are the respondents? Who are
The next surviving personal son of Bahadur and Salma. Two sons are
Bahadur's son is Nimai.
Nimai and Lakhdar, two sons.
Nimai and Lakhdar. So these Basanti and Sumitra, they belong to that.
Nimai family.
Nimai family kahan rahasi tale?
Se Nimai ଝିଅ.
সেটা আপনার দেখিয়েছেন ভুল
আগে
এমনি কোন
Nimai the grandfather না হলে Nimai
আজ্ঞା নিমাই ଯୋଉ ଗ୍ରାଣ୍ଡସନ୍ ନିମାଇର ଝିଅ ତ
ହଁ ଯୋଉ ବାସନ୍ତୀ ସୁମିତ୍ରା.
So you should have shown it like that in the other time.
They are not party for
All right. So they are the daughters of
Dugi, the plaintiff. They are daughter. They have since Dugi contested the suit, filed the suit. They are not included party, but as the judgment reflected their name,
What is suit for?
Suit for declaration of right title interest, alternative prayer for petition.
Yes.
The court hold since the property is the joint family property, the declaration of right title interest is not possible, and that has been denied. But hold the property being the joint family property, and the Dugi is the widow of the Nimai is entitled to file a petition suit in view of the Hindu Women's Right to Property Act 1937. The defendant's plea before the judge, such a suit is not maintainable. In view of that, the act is no more force, has already been repealed in the 1956. And the court holds the act has no overriding effect since this is a special conduct relating to women's property, and the parties are governed under the tribal community. The Hindu Succession Act is not applied.
They are tribals.
They are tribals.
So the Hindu court doesn't apply to them.
The Hindu Succession Act is not applied to them.
Yes.
This such finding has been challenged before the appellate court, Appellate court
So what
confirmed
is wrong in this finding?
the Hindu Women's to Right to Property Act has been repealed as a whole, not a repeal as to the extent the persons belong to Hindu and the persons who are governed under the Hindu Succession Act. The entire act is lost its force after repealing. Then the claim for petition on the basis of such act or provision of the such act is not permissible. That is both the courts below confused themselves as if there is a overriding effect of two statutes.
Let us see the judgment.
The first, I am placing the
Trial
trial
court judgment with the relevant portion.
issue number 1 and 4.
He has not framed any issue in this regard, but whether there was a partition or not, that is the
That
issue.
is page 20 method. Internal page 6, issue
Yes.
number 1 and 4.
Yes.
Admittedly, the suit land was the joint family property of Nimai and Lakhinder. There is also no dispute that the Salma widow of Bahadur died about 2 years back. In case of a Poti Lakshmi Perumala versus Poti Krishna Manama, decided on 1964, Honorable Supreme Court observed when the act says that she will have the same right as her husband, and it clearly means that this would entitled to allotted the same share as her husband would have been entitled to had he lived on the date on which such a claim petition.
She claims petition.
She claimed her petition.
Hmm.
As per the above principle, widow Nimai shall be entitled to the share which her husband would have been entitled as on date of filing of the suit or on the date of passing of this judgment. After death of the Salman, Nimai would have been entitled to 1/2 interest in the joint family property as on today. Said 1/2 interest of Nimai shall develop upon the plaintiff. Plaintiff being a woman has right to claim partition of the joint family property as per section 3, subsection 3 of Hindu Women's Right to Property Act 1937. This is the basis for granting relief of partition under section 3 of subsection 3 of the Union. That is lost in force since that has been abolished since 1960. I have
Now, what will be its effect if the parties are tribals?
parties are they are governed under the Hindu law and
How-
that
how-
extent,
how does-
old Hindu law, my lord.
Old Hindu law, yes.
That to that extent, one judgment is essentially came before the Honorable Appellate Court related to women property in Kamalanathi case, my lord. The Honorable Appellate Court though recommended for amendment of the law, but says my lord, para 6 is the finding of the court with regard to assessment of compensation amount on the instances of daughter, my lord.
Please place it.
Mallet. A short question is posed for consideration of this court is whether the appellant petitioner, being a daughter, is entitled to the share in compensation with respect to the land acquired or survivors basis under the provisions of Hindu Succession Act. At the outset, it is required to be noted that the appellant belongs to tribal community and is member of scheduled tribe. As per section 2(2) of Hindu Succession Act, the Hindu Succession Act will not applicable to the members of the scheduled tribe. Therefore, as such rightly observed by the High Court, the appellant cannot claim any right of survival under the provisions of the Hindu Succession Act. Therefore, so long as section 2(2) of the Hindu Succession Act stands, there is no amendment. The parties shall be governed by the provisions of section 2(2) of the Hindu Succession Act. Therefore, though on equity we may be with the appellant being the debtor and more than approximately 70 years having passed after the enactment of the Hindu Succession Act, and much water has been thrown thereafter, though we are prima facie opinion that not to grant the benefit of survivors to the debtor in the property of the father can be said to bad in law and cannot be justified. In the present scenario, unless the section 2(2) of the Hindu Succession Act is amended, the parties being member of scheduled tribe are governed under section 2(2) of the Hindu Succession Act. It is observed and held by this court in case of Mohan Paikal Supra that when there is a conflict between the law and equity, the law will.
So that, I mean, the Supreme Court observes that section 2(2) is a bar.
2(2) is a bar and the woman member has no right of survivorship. In this case, to this observation, finding of the Supreme Court and the present case, both the courts granted relief by bypassing that they have a right on the Women's Property Act. But such act has already been abolished.
Let us see how this was dealt with by the First Appellate Court.
First appellate court in para 11 that has been considered.
Para 11. No, para 11 kind.
Para 11 page 12.
Yes.
With para. Now coming to the main contention of this appeal for which appellant has preferred appeal. As per the stand of the appellant, defendant, the parties in the suit who are scheduled tribe should be guided by old Hindu law Mitakar school. After enactment of Hindu Succession Act 1956, all the earlier acts enacted relating to the right of the property automatically repealed, and old Hindu law will be applicable in which the present plaintiff being a widow entitled to enjoy only the interest of her husband or maintenance but son not possess the property as a co-personal. As per Mitakar school of Hindu law,
I think this is the correct proposition. This is the correct proposition.
This appellate court also applied the property granted relief by applying the repealing act.
Okay.
Thereafter, saying that this is has no overriding effect with the Hindu Succession Act. Question of overriding effect is came to question when there is two act is in force and there is a conflict in between the two acts, and when that case, this who is the special statute, who has the more effect is required to be considered. It is initially Hindu Women's Property Right Act has been enacted to protect the right of a widow in respect of the joint family property, as there is no such codified law. After next codification made in New Hindu Succession Act, that law has not required, the legislature should repeal the same under section 31 of the act as a whole without any specification, this act applicable to the confining to this act or as a whole it has been repealed. That has not been taken note of by the both the courts. Gazette notification number
See, go to judgment को refer करछंती Ninja Naik versus Bhimo Naik.
that is confining to the overriding effect. This issue has not amended provision that has been repealed as a whole. Not it was repealed to the extent applicability of to the persons under the Hindu Succession Act, that might have been different.
Hindu women's right to property in 1937. You agree with that? It's repealed. That is known. That is not.
So people, there is no existence of such act. There is no question of overriding effect.
All right.
I have
What are the questions of law?
formulate additional question that I did.
Provision of the earlier act to be added in the operator to I think 1 and 3.
1 and 3 better.
1 and 3.
आज जो जिनोलॉजी से जो पेस्ट होई छी पर टिके मोर क्लैरिफाई करला चेष्टा करछि क्लैरिफाई.
All right.
Facts are not dispute. Property, joint family property belongs to our family as a food of main purpose.
Third learned counsel for the appellant. Also peruse the judgments passed by the lower appellate court as well as the trial court. Also peruse the appeal memo along with the grounds raised therein. Stop. The appeal is admitted on the following substantial questions of law. These two. All right. Actually, whether both the courts are correct in applying. You can say whether both the courts below committed an error in applying. You can say that. Committed an illegality. Whether the courts below. Yes. जहाँ अच्छी कर दिया तो अपने करेक्शन
डिस्कस what file
wait. Issue notice. Only sole respondent, isn't it?
sole respondent.
Issue notice by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. LCR be called for. What is the IA?
I have the civil court commissioner deputed for carving out the final degree. Seal and
Final degree has been passed.
final degree has not been passed, going to be passed. Final degree proceeding may be going on. This same shall not be signed, sealed and signed. That is normal in the partition.
We can stay operation of the order, we can stay,
My lord.
isn't it?
Obliged.
In the interim, it is directed that operation of the
Judgment.
impugned judgment and decree passed by the lower appellate court shall remain stayed till the next day. Is this matter कभी कुछ है? 24th June.
Obliged.
ये रखिए, हम अभी रखिए.
Item number 2,
May I please, my lord? The petitioner is the wife. The wife has filed this application for transfer of CP case number 35 annexure 3, CP case number 13 of 2023 from the Court of Law and Judge Family Court Jaipur to the Court of Law and Judge Malkanagiri. I have written Law and Judge Family Court Malkanagiri, but today morning I ascertained that Civil Judge Senior Division is taking. I will correct that. And in other cases, in domestic violence case and 125 case, which was running at Malkanagiri, I have annexed these annexure 1 and 2. The husband has contested and the final order has been passed by the Honorable STJ Malkanagiri.
Where have you stated that you are residing at Malkangiri? You para 11, all right.
Hello.
Then counsel for the petitioner is permitted to correct the typographical error in the transfer petition in court. Third, issue notice to the opposite party by speed post, fixing a short returnable date, requisites be filed within, requisites be filed by tomorrow.
Well.
List this matter,
13th May.
Huh?
13th May.
13th May. Further proceedings in CP number 13 of 2023 pending in the court of Learned Judge Kota.
Family Court Jaipur.
Pending in the court of Learned Judge Family Court Jaipur shall remain stayed till the next date.
Obliged. And I may pardon. File 24 টা আসছে।
Item number 3,
May be losses. In this case, my lord, petitioner seeking to observe as Ganashikya to the Parut Sikha Sahib, my lord. In the light of Dhananjay Charan Dey case, my lord. Initially, petitioner are education volunteers, my lord.
Dhananjay Sonde, I think several matters have been
Lordship
disposed
has
of.
also.
Your lordship have
case,
directed
my
the concerned authority to take a decision.
In light of Dhananjay Day,
Yes.
isn't it? The same order can be passed, man.
Yes. All the cases.
Disposed of.
In on other connected only different dates is representation date is different.
Representation date is filed day. You can put date, city date of representation which is city dispose of reference.
Your lordship can provide me a copy of the mail.
Representation which is that will be Kuru.
Your lordship can provide corrected copy.
Eh?
Corrected copy, my lord.
I should be so this is corrected copy there. Yes.
Obliged, your lordships.
item number 4,
Pass out. Pass out.
item number 5,
That part had matters.
Yes. Applicant to be capable and counsel appearing for the application original should the correct Khannagar only. There is the file, but the documents relating the selection officers are not available. Request
Pass over.
entire file. The entire file you are required to produce, isn't it? You have the file. What does it show? You go through the file and apprise the court. Khannagar and Mojipura.
My lord, actually, as per the submission of the authorities, my lord. In fact, my lord, when there was a proposal for creation of new Anganwadi centers and mini Anganwadi centers, the proposal was for creation of Khannagar mini Anganwadi center. The original Anganwadi center, my lord, that consists of 3 places, 3 villages. That covers 3 places, that is Artamur, Khannagar and Mojipada. But this particular mini Anganwadi center, there was a proposal for creation for Khannagar, and accordingly for Khannagar it was created. And thereafter, my lord, an advertisement was issued. Now, my lord, that is the real point of all the suspicious
Let us go to the
activities, my lord.
advertisement then.
Pardon, my
Let
lord?
us see the advertisement, then I can appreciate. Advertisement is Annex 2.
My lord, I am.
Annex 2 at serial number.
My lord, page, your lordship is
Yes,
the.
I've seen it. Khannagar.
That-
column number 8 ହେଲା ମଝିପଡ଼ା ଗୋଟେ ହାତରେ ଲେଖା ହେଇଛି anyway.
I am submitting, my lord. The before lekha is Khannagar. The name of what my friend is submitting, the name of the Anganwadi center is Khannagar, that is admitted. The area of jurisdiction is Khannagar and Majipada. See, my friend is submitting the name of.
ମଝିପଡ଼ାଟା is written by hand.
Yes, and that is written by hand.
Alright. Then
So, my lord, now the points remain, my lord.
according to you, the name of the Anganwadi center is Khannagar. And
And-
service area is, that
Khannagar.
must have been defined in the
Khannagar.
Khannagar. Only Khannagar.
Yes.
Not Mojipura.
Now, no. Now, my lord, when this Khannagar, mini Anganwadi center was created and the advertisement was issued in the DTV page, my lord, there are two types of advertisements which are produced before lordship. In both the advertisement, my lord, contents are same. How the contents are same, my lord? So far, the mini Anganwadi center's name is concerned, my lord. It is reflected as Khannagar, and below that, it is Mojipada. And with respect to the service areas, covering the service area, my lord, it is Khannagar. Then, my lord, another set of advertisement, what it has been relied upon by the petitioner also, my lord, and both the documents, my lord, that has been obtained under the RTI Act. These advertisements, also the other advertisement, my lord, that has been obtained under the RTI Act. And, my lord, there, without any initial, my lord, there is no there is only scoring down, my lord, that Mojipada under the what I call it, my lord, that is mini Anganwadi center's name. Mini Anganwadi center's name, my lord, that has been scored out. But interpolation of that Mojipada towards the service area and putting the initials, that is the second one, my lord. Now, my lord, the issue is that, my lord, whether the mini Anganwadi center's name is Khannagar or Khannagar Mojipada, or the service area is Khannagar only or Khannagar Mojipada. It includes Khannagar Mojipada. So it is the third round litigation, my lord. This is the second round appeal order. So what it has been stated before the Honorable Court, my lord, in the previous case, and that has been also annexed, my lord. And on the basis of which, my lord, this second appeal order has been issued. There, my lord, there was a direction to conduct the inquiry by the collector. And accordingly, there was a inquiry which was conducted, joint inquiry it was conducted by the revenue officers, including the CDPO and the Anganwadi supervisors. There they found that this is separate. This is no way connected with the Khannagar. Then, when the previous case was disposed of by this Honorable Court, my lord, at that point of time, the ADM was directed to reconsider the entire matter, including the report which is to be produced by the collector. Now, the present inquiry, my lord, present appeal order, my lord, which has been issued by the ADM. Now, there it says, my lord, that this is not actually covering under the Mojipada area, and there is a tampering in the advertisement. With respect to that advertisement, my lord, there is a tampering. Now, my lord, with respect to the other parts, my lord, I could not get any information. But I have a file, my lord, in original, I have the file, wherein it relates to the application forms which are received from the different individuals. My lord, including
It must be containing the advertisement, original advertisement.
that is not there, my lord.
How come?
No, it is not.
The file must have been started when.
But we are admitting, my lord, we are admitting these two advertisements have been issued through that
They are contradictory.
content.
They are
That's
contradictory.
so, my lord, I beg pardon. There is only one, there is one initial is there, in another T application, there is not initial, but there is a handwriting is there.
So how will the court arrive at a conclusion, definite conclusion?
Yes, I am satisfied, also.
That's all.
When I find a complete, I will satisfy.
But my lord, in this case, my lord, now if I will go through the individual application submitted by the present applicant as well as the respondent 4, my lord, they have applied for Khannagar, mini, Anganwadi.
No, the question is, there seems to be no doubt that the center's name is Khannagar.
Yes,
But the question is, what will be its service area?
The entire allegation and the entire argument, now it has been advanced by the petitioner in this case, my lord, basing upon the statement what we had made in the previous counter, where we have indicated, that is why there was a direction by your lordships on the previous occasion, that our stand in the previous counter and the document what affidavit we are submitting, that is running contrary to each other. There we had indicated mini Anganwadi Center, Khannagar, bracketed Mojipada.
No, there must be some notification indicating the service area of this particular mini Anganwadi center.
Should have been, yes.
When a decision is taken to establish a
Yes, sir.
Anganwadi
Yes,
center, the natural corollary is that it must have a defined area.
Well, it is Khannagar.
So where is that document? That is exactly what I would like to see.
Yes, with respect to the,
When you started your argument saying that there are 3 different areas. One is that.
Yes,
Amul and Majapur.
Yes. So that document the court would like to see. For defining the service area.
we wanted some clarification from the authorities.
No. Defining the area of
Yes,
Khannagar mini Anganwadi center.
that is also, my lord, available, I think, my lord, in some of the pleading,
Yes.
because it is 4 to 5 documents, my lord, they have chronologically arranged it and they have provided.
You will find out that notification. You see, this Khannagar mini Anganwadi center must have been established at some time in the past.
Yes, my lord.
There must have been a notification to that effect.
Yes, madam.
Once that very notification would have defined its service area.
Yes, madam.
That is the document which will show. If that document is there, irrespective of whether a tampering has been done or not, that would be immaterial. We know what is the service area. And of course, here, Mr. Pratap again,
Yes.
but you get the point.
Yes, madam.
I want to go to the root
Yes, madam.
to find out that Khannagar Anganwadi center was established by such and such notification.
Yes, ma'am.
That very notification is important. That will show what is the.
The proposal and the approval both are available with me, but the notification defining that particular area is not available.
You will let us pass on the proposal.
Yes,
and the approval. That will.
Yes. It is DIH.
କୋତା କୋଣାରେ ମୁଁ ଦେଖିଦେବି ଏଥିରେ ଯଦି ଅଛି ତ
ସେମାନେ ଗୋଟେ କହିକି ଦେଇଛନ୍ତି ଏଟା ମୁଁ ରେଫର କରିଦଉଛି ମଧ୍ୟ ମୋର ଏଇଠୁ. Yes, my lord. That is annexure A/2 series. My lord, it is the affidavit filed on 22nd February 2019.
Yes.
Counter affidavit.
Proposal for opening of additional Anganwadi centers and
Yes.
mini Anganwadi centers.
Yes, Miller.
Yes.
Here it, the
My lord,
page is
relevant page is
10, Miller.
10.
ସେଥିରେ କିଛି ଜଣା ପଡୁନି
Serial number 59, my lord.
ଆଜ୍ଞା 59 ରେ ତା ଦେହରେ ଏସେ କଲମ ନାହିଁ
No,
Service area
କୋଉଠୁ
Nice service area.
ସର୍ଭିସ ଏରିଆ ପାଇଁ ଗୋଟେ ଥିବ ନୋଟିଫିକେସନ ଥିବା
Yes,
ଦରକାର
ma'am.
ଡିଫାଇନିଂ ଏଇ ଘର ଠାରୁ ଏଇ ଘର ପର୍ଯ୍ୟନ୍ତ ଏଇ ଲାଇନ ରୁ ଏଇ ଲାଇନ ପର୍ଯ୍ୟନ୍ତ ପୁରା একদম exactly
Yes,
that notification always contains the exact particulars ଏବଂ ଲେଖାଯାଏ from the house of Mr. X to the house of Mr. Y.
And surprising also, my lord, in this particular advertisement also, my lord, that is missing. But whenever I have come across the other advertisements, my lord, with respect to the mini Anganwadi areas particularly, there the service areas are also from
Yes,
A ghar
yes.
to A ghar ମଧ୍ୟ ଲେଖା
ହଁ ହଁ ମୁଁ ସେଇଆ କହିଲି Mr. X ରୁ Mr. Y
ଏ advertisement କିଛି ନାହିଁ.
ଏଥିରେ କିଛି ନାହିଁ
I am
advertisement ନାହିଁ
ହଁ.
but advertisement even if it is not there in the advertisement if the notification is there if the service area has already been defined
Yes.
so that document is required to be seen by the court.
Yes, ma'am.
We have heard it many times.
Yes.
I don't want to adjourn it again. I wanted to close it today. You have to find out that document.
I will get that, man.
Mr. Pratap, you.
Well, I would, your lordship, may-
Otherwise, what will happen is, if I consider your argument or even the argument of the other side, it will only be on conjectures. So this court will be called upon to draw inference. Why? If there is a document, why the inference should be drawn?
yes, Miller.
If there is a document there which clearly shows what is the service area.
Yes, ma'am.
One document I am just
Please,
realized.
please.
the counter filed by the private opposite party. I am relying on the document of the counter filed by the private opposite.
Opposite party number?
That is
Five.
yes.
All right.
Counter filed by opposite party number 5.
Yes.
One document they are relying. Your lordship may see the document at Annexer B रे से मान देइछंती. Annexer B रे से notification then next page रे page मत करनांती. Page by 20 my lord. So got it my lord. Page 20. गोटे पेज नोटिफिकेशन आएगा. समन्वित शिशु विकास योजना कार्यालय डेराबीस. got it?
Yes.
Yes. Here ये जे देखो तले लेकोट रिकॉर्डिंग ହେଇଛି एटा पंचायत ଅଛି आज्ञा. एठी भी अछि वार्ड नंबर 10 खाननगर मझीपड़ा एरिया ऑफ जुरिडिक्शन. योर लॉर्डशिप में राइटली कॉलम एटा गोटे देइछनी
सीरियल नंबर केते?
सेटा सीरियल ना एठी मत गोटे देइछन डॉक्यूमेंट एटा पेजिंग करनाती एटा ठीक आके देख दियौ.
That they have given.
हां मते देइछन काउंटर से मते ऑपोजिट पार्टी मते काउंटर देइछ आके देख दियौ. मत देखे तुम सेठी लेखा ହେଇଛି हेडा पंचायत जाइछि नोटिफिकेशन एरिया ऑफ जुरिडिक्शन इज खाननगर एंड मझीपड़ा. Then my lord, the next page you lordship may see. The next page. If there is any objection within 10 days, the allegation has to be filed. এই মানে রহিলে the objection has to be filed.
This document
He has supplied. It's a copy মতে দিয়েছেন তাই.
is not available in the file.
Well, if he is referring to the counter dated 23rd September 2015.
हाँ सेप्टेम्बर तो अच्छे सेटा मते कॉपी से देइछ नागे से डॉक्यूमेंट आगे देखंतु
Notification. अब नेक्स्ट पेज 10 दिन भीतर एलिगेशन देबार अछि. किंतु she has not filed any allegation.
That is all right. That is all right.
When we become unsuccessful.
No, no. This court would first like to give a finding that yes, or to be sure that this is the
area of jurisdiction, my lord.
Then I will come to the procedure.
Yes, ma'am.
Counter of the there would miss case counter of the condition.
मते काउंटर देइछ ना अपन कॉपी देना से कॉपी टेक.
You have to give the
मते डेट टा केते तो से सार दे ना काउंटर रो डेट से दिस काउंट टोटल दे दिछ.
counter is no.
सेटर कॉपी देइछन से बस. तेडो हो पाकरे भी नाही.
It is not there in the court record.
ए काउंटर टा
And it's a Odia document. Raptesu Swapnomoyi Todhan इत्यादि RTI Act of application.
हां
तापर that विज्ञापन संख्या 501 16/12/2009.
तो ये डॉक्यूमेंट देइछन तो दे द नेक्स्ट पेज
That particular document is not there in the file. File बाहर
मते भी देइछन डॉक्यूमेंट सब डिटेल्स करेक्ट.
So what are you saying? That they are not submitted objection. That's all right. That's all right. That will be.
My submission of your lordship. Suppose I am in a wrong footing. I was in a wrong footing. There is a clear cut direction informed by the government to file an objection within 10 days. There is a clear. They have supplied. That document is not with me. They have supplied me to within 10 days, but they have not filed so. In 2002, it is a document of 2010. In 2012, when she became unsuccessful, she filed a petition before the petition before the ADM, and when it was done not disputed, then it. My humble submission before this honorable court. As I relying upon decision of the honorable Apex Court as a coordinate bench of this honorable court. In the case of Madanlal and others, AR to 1995 period, Madanlal and others, your lordship may go to come to the page para 10 of this judgment. Para 10 of the judgment, Minister.
This is the settled position of law.
Judgment also.
Unsuccessful candidate cannot challenge. That is true. But here,
There is scope here. Opportunity was given to her to file an objection.
let us go to the impugned order for a moment again.
Miller.
Impugned order is Annexure 1.
Yes, Miller. See. It. And included annexure 1, Miller. Only that stand is the audio advertising has been tampered. Your lordship categorically directed to the government whether any action has been taken by the taken against the concerned CDP who was was tampered that agreement, in that also categorical directed to the government.
Where is the original advertisement? Yes, Mr. Patna. How can the government not produce the original advertisement? Then how will this court arrive at a finding? Because he said, the ADM says, due to manipulation, tampering in the advertisement, respondent number 2, Sanjukta Dalai got an engagement.
And they have reached to such a conclusion on the basis that, my lord, there are two types of documents, whereas one is without any initial and another is with initial.
So,
That is the-
if the original advertisement is seen, which must be on the
My lord, 3 files are available with me, my lord. କଣ ହେଇଥିବ 2010 ରୁ ଆଜି ଭିତରେ ବୋଧେ ହୁଏ କିନ୍ତୁ ଦିଟା ଯାକର ଡକ୍ୟୁମେଣ୍ଟ କୁ ସେମାନଙ୍କୁ ଆର୍ଟିଆଇ କୁ ଦିଆଯାଇଛି। ଆଉ କୌଣସି ତାକୁ
advertisement ନାହିଁ।
ଆଉ ସେ ଦିଟାକୁ ଛାଡିକି ଯୋଉ ଦିଟାକୁ ବର୍ତ୍ତମାନ କୋର୍ଟରେ
What happened, I am submitting one thing. What happened at that time? No one is the CDPO at database block. CDPO in charge is Pratima Das. The maternal uncle of the petitioner is the BDO of that block. They creating one conspiracy at suppress the materials, one prepare one advertisement by mentioning the name of the Mojipada. Mojipada belongs to Khannagar. Mojipada belongs to Attam. It's two separate things. They take the first they prepare the list, and in the list which have been they placed Sanjukta Dalai village Ortamul in the serial number 9. They categorically mention.
No, here what is you see the finding is, Mr. Patnaik,
yes ma'am,
it has been it has been manipulated and tampered at the instance of CDPO database. The CDPO is a government officer.
yes. And your lordship wanted to know that whether
What action was taken?
action has been taken or not, my lord. That also we have stated, my lord. The authorities have not initiated any action, my lord.
At that time, no one is head clerk is the CDPO in
I have heard enough.
One document.
No, I have heard enough. Whatever you want to say it through your written notes. Yes. And again, I ask you, is there any chance of obtaining that advertisement?
Advertisement, my lord, I had insisted upon, but I can ensure, my lord, to produce that copy of that government notification with defining that surface area.
Well, one more chance I will grant you then. One more chance.
Yes, only to
In
that.
course of hearing, heard further arguments and part. Stop. In course of hearing, it has been contended that the service area of Khannagar Mini Anganwadi Center includes Mojipada, whereas the original notification defining the service area, which was reflected in the advertisement, does not say so. Stop. Then State Council has produced the files, but the same does not contain either the original notification defining the service area of Khannagar Mini Anganwadi Center or the original office copy of the advertisement dated 16/12/2009. These documents are vital for adjudication of this case. List this matter next week. Learned AGA shall produce the aforementioned documents for perusal of the court positively. Stop. You
A copy of the order.
free copy of this order be handed over to the State Council for compliance.
Yes.
Mr. Patnaik,
Yes.
tell them if they don't produce, I'll pass an adverse order.
Yes.
I'm not passing it now, but if they don't, then yes. Yes, we'll take it up next week.
এই ডকুমেন্টটা যেটা আমি আপনাকে স্যার দেখাইলি সেই ডকুমেন্টটা ফাইলে নাই ইট শুড বি ইন দ্য ফাইল এর মধ্যে কপি দিয়ে দিয়েছেন স্যার কাউন্টারে
সেটা ফাইলে তাଙ୍କ কাউন্টারটা
সেটা এখানে এক্স্যাক্টলি ইম্পর্টেন্ট ডকুমেন্ট
এই সরি ମୁଁ ତାଙ୍କୁ କହିକି ବସିକି ଡକୁମେଣ୍ଟ ଟିକେ ଚେକ୍ କରିଦେଲେ ଯୋଉଟା ଆମର
ମତେ ବି ଗୋଟେ copy ଦେ। ଆପଣ ତ
ଦେଖିଦିଅ ସେ ଡକୁମେଣ୍ଟଟା ନାହିଁ
ଷ୍ଟେଟ ପାଖରେ ବି କପି ନାହିଁ ଓନ୍ଲି
ମୋ ପାଖରେ ବି ନାହିଁ ମୁଁ ତାଙ୍କଠୁ ମାଗିଛି
ନାଇଁ ସେ କୋଉଠି ଗୋଟେ ଭୁଲ ହେଇଥିବ ଦେଖିଦିଅ ଯଦି ହେଇଥିବ ତା ଆଉଥରେ କପି ଦେବେ
ମୁଁ ଗୋଟେ ଜେରକ୍ସ କରି ଯଦି କହିବି
ମୁଁ ଦେଇଦେବି ଆଉ
ନାଇଁ ସେ ଦେବେ ସେ ଦେବେ
ୟେସ୍ କାରଣ ଏଇଟା ଇମ୍ପୋର୍ଟାଣ୍ଟ ଡକୁମେଣ୍ଟ ସେ ଯୋଉ ମତେ ତାଙ୍କ ଡକୁମେଣ୍ଟ ମୁଁ ରିଲାଏ କରୁଛି ଇଟ୍ ନଟ୍ ମାଇ ଡକୁମେଣ୍ଟ ନେକ୍ସଟ ୱିକ୍
ନେକ୍ସଟ ମଣ୍ଡେ
ଅବଲାଇଜ୍
Item number 6.
May I please your lordship? The petitioners have challenged the notice under Annex 3 in cancelling the election as Asa Karmi without any authority and without giving any reason, your lordship. Annex 3 is the improved notice wherein they have cancelled without saying any reason.
selection process for 6 numbers of Asa Bhuvanavasi he will cancel yes
And they have filed the counter disclosing that since there was a complaint, according to the complaint, there was a inquiry was made, and in the inquiry they have said that since there was no mapping of service area of Asa Karmi, the selection was cancelled. First, second thing is since the last date was on a holiday, that is Sunday, so they have cancelled the selection process. And so far as the mapping area is concerned, your lordship, I have filed on document Annex 6 to the regender that there was a mapping area of the service area of the Asa Karmi, your lordship. Annex 6 to the regender, your lordship, kindly see.
yes what is the meaning of area mapping
My lord,
what is the meaning of area mapping
the example that before your lordship are saying that the X to I
you are referring to Asa 3
My lord,
Asa 3
Asa Karmi, your lordship.
Asa 3 ତ ଏ ବହୁତ ଆଶା ଅଛି ନା କୋଉଥର କୋଉ ଜାଗାର
1, 2, 3, 4, 5, 6. There are 5 prisoners.
আচ্ছা Asa selection আচ্ছা হোক so what does it say this is a mapping area mapping for selection of 6 numbers of additional Asa along with the existing Asa in Bhuvan NSC area.
But they are saying that since there is no mapping of no service area, lordship.
All right.
The false statement they have given. And so for the second part is concerned, they have said that it is on Sunday. So then there would have been more applicants if had it been on Monday.
Let us see the affidavit counter affidavit.
Paragraph 9. On the last occasion, your lordship had directed to explain on the basis of the inquiry report that has been annexed as annexer H/2.
Paragraph 10 they have answered. It was observed that
Just an inquiry report annexed H/2. Yes, now I remember.
Your lordship wanted more clarification on the various paragraphs given in the report.
No. The mapping that you are referring to, that was done after this notification.
no, madam.
That was in 2022. This inquiry report is in 2021.
Yes.
2000.
22. The area mapping was done in 2022, sometime in 2022. Find out. You can see it. At the bottom, everybody is signed.
Yes, your lordship.
So, as on the date of, you see, 29/6/2022. Now, this inquiry report annexed H/2, this was on 2011-2021.
12/11/21.
Lekha is 2011.
Oh, sir.
Yes.
Date of inquiry.
Signed it.
12/11/21.
Yes, yes.
So they say that on that day there was no mapping. The document that you are giving is of 2022, which is subsequent to this.
But even if that is accepted, your lordship, it is the fault lies with the opposite party, not with
What opposite party?
the authority. The fault lies with the authorities. The prisoner should not suffer for the fault done by the authority.
No. What was it was just an advertisement.
Advertisement was issued pursuant to the guideline, your lordship. In the advertisement, it will also kindly say Annexure 1 to the advertisement. There are certain conditions and norms are fixed.
So how do you accrue a right? Only because you are one of the applicants, and subsequently the government takes a decision.
No, I agree. We have been selected.
6 numbers.
6 numbers have been selected, lordship.
Even if you are selected, Only except for a legitimate expectation, you do not accrue a vested right of being
They have
appointed.
been selected and they are called on telephonic message that come and join on 28th. Selected on 27, join on 28th, Your Lordship. And Your Lordship see the Annexure 1. Annexure 1 is the advertisement. There are certain terms and conditions and the norms and fixed.
What is the law in this regard, Mr. Pal?
Law, I have relied upon.
Go back to that.
Once the selection process started.
So you go back to Sankarshan Das, Constitution Bench decision.
No, that.
What does it say? Sir, please listen. What does it say? Being included in the select list does not give you a vested right. So now it is. Please have patience. Unless you understand the mind of the court, you will be submitted on your own.
I'm sorry.
So you being included in the select list does not give you a vested right of appointment. The government or the authority may still not select or give you appointment. Government may cancel it also. But the law is that cancellation cannot be arbitrary. So you must hit at the point whether it is arbitrary or not. Whether that decision that on the basis of which they subsequently cancel the advertisement or cancel the entire selection process, you have to prove that that decision was arbitrary. Only then the court can interfere.
They have arbitrarily done it. In this regard, I rely on decision of this honorable court.
No, come to the facts. Then we will go to the law. Come to the facts, na. Court arbitrary hele kahi kala kontu. Where is that decision? Simply the Annex 3 is hereby cancelled and a fresh notification will be released from after organization of subcommittee.
You'll also kindly see the Annex 3, the notice itself.
Annex 3, yes. But with this, they are cancelled without
assigning any reason.
Yes. Now they have tried to develop their case in the
Filing the counter saying that no mapping area and the last date was Sunday and had it been Monday, there would be more applicant. My reciprocal submission is, Your Lordship, once the selection process is started, the authorities cannot touch the selection process.
Where is that reason? Where have they stated the reasons for cancellation of the advertisement or the selection process?
Para 10. Para 10 of the counter.
Yes. Please place it.
Para 10. The findings are as follows. Internal page 7.
Yes.
It was observed that prior to the notification, selection subcommittee has not finalized the ASA service area by mapping. The ASA notification has been done for whole urban area without any mapping. After publication notice, it was supposed to aware the general public on role and responsibility of ASA, process for submission of application, selection procedure, etc. But the same had not been conducted. As per the ASA notification, the last date of submission of application was 22/8/21 Sunday, which was a holiday for which applicants were unable to submit the application form as there is no adequate ANM to receive the form. ASA notification was published for whole urban, but after submission of application form by the applicants, subcommittee had decided to select from particular wards. It was also observed from the provisional merit list that 2 numbers of participants from one particular ward will be selected, for which it may be difficult to work in another assigned ward. Hence, it was suggested by the inquiry committee to select ASA from the whole NAC as per notification or may be cancelled. The notification for selection of ASA, it is cancelled prior to notification. It is cancelled prior to notification, the service area of ASA to be finalized with observing the geographical location of wards, population and area present ASA.
Yes. What decision were you referring to?
My lord. After starting of selection process, norms should not be changed. And my lord, so far as eligibility criteria, the application again the last date of application.
Yes, Mr. Das.
Yes, Lord.
Your cancellation notification does not spell out any reason. Simply says it has been cancelled. Since some persons had been selected, I think it was necessary for the state government to come out with reasons as to why they decided to cancel the.
Only reason is on the basis of this inquiry report, they have resorted to this annexure 3.
No, but they have not referred to that inquiry in the notice, cancellation notice.
No, they have not expressly said so.
So as I said, they may not have a vested right of being appointed, but there's a legitimate expectation. And secondly, the law is that the decision cannot be arbitrary. It is up to you. You may cancel it. You may decide not to fill up the vacancies for some reason or the other. You may abolish the post also.
Yes.
Subsequently, because of the necessity then existing. But then decision has to be a reasoned one. It cannot be arbitrary. Anyway, third arguments. Judgment is up. Parties may file the note of submissions and memo citations within a week. Very good.
I don't know, 7.
The last order, my lord, had directed the opposite party number 7 to file his reply.
Copy of the additional report filed on behalf of served upon a counsel. Yes.
I got it today morning. I do not want to blame him because he served it today morning. So I have to go through that, sir.
Why did you wait till today morning?
Inadvertently, I missed it. I inform the clerk to supply the copy. But
Inadvertently, what is the meaning of inadvertently? But there's a specific direction to, what is this? For this only the case will be adjourned.
I mean, my humble apologies, Your Lordship, but
Your apologies will not help. Your 2012 matter. You have to be very, very careful. You are a young counsel. Why are you not showing any kind of promptitude? All right. Copy of the additional affidavit filed on behalf of opposite party number 7 has been served upon learned counsel to the petitioner today morning. Who wants to go through the same in order to submit his response? Place this matter next week.
My lord, say a week after, because this is from my bunch. I have to ask him and come a week after.
Sir, next week, next week. Next week.
Understanding that next week,
Next month, 29th?
29th. Yes.
Item number 8.
Track my lord PET teacher. After selection, whenever he joined the institution, he's joining and
This is for Kotak.
Only one point has to be decided by your lordship. Your lordship may kindly see PET.
11 posts.
11.
11.
My lord.
So, what happened? You were an applicant.
I am the applicant.
Then, Annexure 8.
My lord. Annexure 7 is the provisional selection list.
No, Annexure 8 of final merit
It is
listing.
the final selection list. Thereafter, my lord, appointment letter.
Final select list, where is your name?
My name.
Page 25.
But your lordship will find at page 26. Serial number 3.
Tapan Kumar Chaudhary.
No, my lord, second one is Tapan Kumar Chaudhary and Pratima Bala Nayak, the first one. Your lordship, it is under SC.
Yes, Siri again, number 3 आपनकर अछि.
Page 25.
प्रथम वाले देवेंद्र कुमार सेठी. Himanshu Shekhar Das.
Under the heading of SC, your lordship. Page 26.
ये पूछा प्रतिमा वाला नायक.
Yes, your lordship.
Page 26.
26.
कौन आपण पढुछन?
Pratima Bala Nayak कथा कहछि.
हां. Serial number 3.
Aage.
हां, तबरे.
I was selected. And
Engagement letter?
Annexure 9 appointment was given. Agreement was also executed. And thereafter I went to the institution to which place actually appointment was given. Then the headmaster refused to accept the appointment.
Well, on what ground?
No ground was assigned. Thereafter, I have come to the district education officer and so immediately informed on 4/1/2013 under Annexure 11 series page 29. That inaction was challenged before this honorable court in this writ application.
You should have obtained an order at that point of time. to dispose of this representation?
No order was given, my lord.
No, that order you should have prayed for that order. You should have taken that order so that at least some decision.
No, state government came forward saying that my appointment was cancelled. That the counter you.
Let us see the count.
State government has come forward and filed on the counter, my lord, saying that my appointment was cancelled.
Where have they said?
Your lordship may kindly page 7 of the counter filed by the
Para 7.
my lord.
Place it.
But after the applicant was selected and given order of engagement in order to report at our replacement of engagement, Godadharpur High School, Tigiria. But before she reported her joint, there was no specific instruction by the government as to whether the first 3 years of degree of education degree should be honored for the purpose of bachelor degree in professional certificate qualification of PT. Accordingly, the order of the engagement issued in favor of the applicant was cancelled by the such also. My sole grievance before lordship is, your lordship may kindly see the advertisement.
So you should challenge it. This engagement order. You came challenging the inaction.
Inaction.
Now, by way of counter, they have produced the documents showing that your engagement has been cancelled. You have to challenge it.
No, my lord, before that I had come before lordship.
Even all right. Now, this in view of this development, you have to challenge it.
My point, I have to amend the writ application.
Yes, you have to.
My lord, I may be permitted to amend the writ.
No, that's so the court will, you have to make a prayer, the court will consider it.
My lord. But fact remains that your lordship may kindly see the prime.
You see,
I have to.
Mr. Mahapatra, how will the court now come to a finding that the decision to cancel the your appointment was wrong?
But your lordship consider.
Unless you challenge it.
I will challenge it. That's true, my lord. I have to challenge it.
So the court will now see you had come challenging the inaction. Now that that is no longer available to be seen because the decision has been taken.
No, my lord, notice was given to them. After the receipt of the notice, my lord, they have cancelled it.
Maybe they won 2013.
My lord, I will amend that writ application. But fact remains that my lord, the advertisement says the bachelor's degree candidate can apply. Bachelor degree in advertisement, they cannot say 1 year, 3 years, 5 years.
Mr. Mahapatra, you have to challenge it. You don't understand. If you don't challenge it, then how can the court give a finding? Even if at all in your favor. Can the court give? Tell me.
That's true, your lordship.
So this was there, right?
I have to amend the writ.
H.L. Mahapatra, learned counsel for the petitioner, seeks an adjournment. On the ground that he would like to amend his writ application by filing necessary application. List this matter next week. Amendment application for amendment if any be filed in the meantime. No, 1 week. Application for amendment if any be filed in the meantime.
Both the cases. Listen.
Same fact.
Same.
Item 10.
Yes.
Directed the government, they would taken the filing of the application.
That to do.
Yes.
What circumstances Srimati Shokran to do she had on the inquiry but if she had not actually participated in the inquiry. Yes. From the court as to what action, if any, has been initiated in the said order. We'll directly ask the collector to appear.
One last chance.
What last chance, Mr. Das? This order. Tomorrow. This will come, we file the affidavit in course of the day.
On Wednesday.
No. I've given sufficient time. Yes, what do you say?
File for
Yes.
You are ready? You can file the affidavit?
Yes, on Wednesday.
Why is it not complied with? There is no reason why it will not be complied with.
There is correspondence from.
You are ready with the information only the officer has to be. Officer has to be called to swear the affidavit.
Madam.
Yes?
it is only to be brought before lordship through an affidavit.
Yes, you must,
And so it.
as requested by learned additional government advocate, list this matter day after tomorrow.
Yes.
The affidavit, as directed, shall be filed positively in the meantime, after serving copy on the other side.
Well, Thursday, your lordship,
No,
I will remain absent on 24th, your lordship. 25th.
all right, 25th.
Okay.
I don't know, 11.
May I please, your lordship?
Yes.
No, this is an unfortunate case of a professor of quite eminence. Even though the order has been passed after a long time, the writ of the year 2001, where he was illegally terminated without even a show cause to a confirmed professor, that has been set aside. And thereafter, the Honorable Court directed to calculate the admissible pension and pay it within 3 months. Your lordship kindly see I have quoted the order, page 7 of my content petition, last 3 lines. Page 7 of the content petition. Consequently, the petitioner shall be entitled to get all consequential service benefits as due and admissible in law, which shall be computed by the university authority within a period of 3 months as to settle the issue for all time to come.
Yes.
It's a case of 201 originally. If your lordship wants to know the facts of the case, that I would say, but see, here the contempt is this. And they have, with the flimsy ground, by committing second contempt, they have not paying me, they are not paying me the pension, contrary to the statute. Even though they don't say that the statute is not applicable, statute 259 and 260 of the first statute of the university. And they said that this period for which I served in the university, 5 years something, so I'm not entitled. I was a government teacher right from 81.
Yes.
As a lecturer. And after being selected as a reader in the Berhampur University, thereafter I joined as a reader in Berhampur University without service continuity. Lecturer in physics, reader in electronics. Thereafter, an advertisement was issued by the Utkal University for Professor of Computer Science. I being eligible, I applied for it. I was selected. I was confirmed without service benefit, and the statute says section 259 and 260 of the first statute. I joined. And to the misfortune, and this happens with sometimes the authority, in a high-handed manner, they terminated. And it was stayed by this Honorable Court immediately. The evening the decision was taken, even though the university authorities time and again intimated the then Chancellor that there is no reason to terminate his service, but somehow he was bent upon for some ulterior motive and directed. And when the Vice Chancellor in question, who gave repeated letters, when he was out of office, then another new incumbent came. Probably he was a little of the weak spine. They accepted and passed a resolution on Sunday. And when the resolution was passed, it shocked the conscience of some of the professors who were present in the meeting. Being intimated, it was drafted in the whole of the night and it was filed in the next day. Without the impugned order, with the affidavit, the Honorable Court interfered, directed stay. And after directed issue notice by special messenger, naturally in our still earlier time, I will say then in 80s, any order passed by any authority under the state without a show cause, at the time of admission, 99% were allowed. And if there is anything, give a show cause and proceed in accordance with the law. But subsequently, thereafter, little changes. Once it is an authority, a statutory authority, a confirmed professor was dismissed. That is why this Honorable Court directed and posted the case very short durations.
I think we can come to paragraph 26 of the order passed in the writ application. That will, I think, they have.
Yes, yes. So the whole point is
so that I'll understand what is the direction.
My lord.
Because they have given some compliance affidavit. So in order to understand whether that has been complied or not, let us read it.
No.
Paragraph 26.
My lord. That I quoted in my.
No, but I think this will be better.
My lord.
Page 45 of the contempt application of the brief.
The narrations made above and would indicate, though a consistent effort has been made by this court to procure the relevant file dealing with the recommendation made by the selection committee, you will also kindly see that was called for from the beginning. Consequent upon which the chancellor passed the order cancelling the appointment of the petitioner. The chancellor has got no authority to cancel. It's the syndicate always. But for the reasons best known, the opposite parties have not produced the same. Therefore, an adverse inference can be drawn for the non-production of the relevant file for just and proper adjudication of the case. Since it is an old case of the year 2001, and in the meantime 17 years have passed, and after completion of his fellowship at the Singapore, the petitioner had been allowed to resume his duty. This is factually incorrect at Utkal University, but they didn't also file for modification or anything because inherently the conclusion is correct. In the meantime, he has been retired and from service on attaining the age of superannuation. Pendency of this case would cause difficulty in finalizing the retrial benefits as due and admissible to the petitioner in accordance with law. In such view of the matter, this court is of the considered view that since the petitioner has already rendered service till attaining the age of superannuation by virtue of the interim order passed by this court, which has been subsequently modified permitting the petitioner to go for fellowship and research fellowship, and after completion his tenure, the petitioner resumed as professor in the university, opposite party university. This ipso facto indicates that the order of this court has been complied with by the petitioner and also with the opposite party. Therefore, at this stage, if any order adverse to the interest of the petitioner is passed, that order will cause prejudice to him. Therefore, in the interest of justice, equity, and fair play, this court is of the considered view that the order impugned on Annexure 7, dated such and such, as observed above, cannot sustain in the eye of law and is liable to be set aside. Accordingly, the same is thereby set aside. Consequently, the petitioner shall be entitled to get all consequential service benefits as due and admissible in law, which shall be computed by the university authorities within a period of 3 months, so as to settle the issue for all time to come.
The service benefits means your salary, you are getting a current salary.
The salary, with the permission, if your lordship will see the order, entire orders passed in the writ petition, your lordship can see that the file has also, I think it has come.
Where the writ petition? File is there.
The,
what is meant by the consequential service benefits?
Yes.
As due and
the period, because the whole point is that the petitioner is one of the rarest, I mean, say scientists in the country. Now though he was professor of computer science, in electronic scientist, he is ranked as number 29 in the country now. Previously it was 32 or 37, now it is 29. And he is so dignified, he wants to help the people who want to do research free of cost. He can go anywhere and can earn lots of money, but he is not going. Because earning money is not the motto for him. Even though the Honorable Court stayed, without the impugned order, on the very next day, on the hard it on the next day, and directed to issue notice for special messenger to file counter within 4 to 5 days thereafter, the university did not cooperate. Did not file counter.
But he was continuing in service also.
Yes, stay was there. But the point is that, the people who belong having little thick skin, they register many things. And incidentally, here he is a man of extraordinary sense of dignity. He got some pinching and indignified statement in the university. So he approached this Honorable Court, seeking permission because he applied to Santiniketan, applied permission so that he can go. Though he was continuing in service, he could have continued. There was no harm. So accordingly, with the permission in presence of the university, with permission of this Honorable Court, which order speaks for himself, he went to Santiniketan.
Which has been wrongly mentioned as Singapore.
No. It is Singapore is the next. Thereafter going, if your lordship will allow me, before he was going to be punished in the manner illegally, I had warned him because I knew him in a very close angle. Because he happens to be a friend of mine since my college days. That the manner in which the high authorities are going on, you cannot withstand. You go anywhere in America and England. And what he said, I cannot say in the court, which ordinarily now the people cannot believe it. Because he said, the work I am going to do, a simple villager can do here. Why should we not work for our people? Why should I go there? He continued. And after 1 year, he got the kick of dismissal without the so cause, where the peons are not dismissed without the so cause. A professor, confirmed professor, that is why the Honorable Court.
That was set aside.
That was set aside, but after 15, 17 years.
Yes.
Then we went to go Santiniketan with permission of the Honorable Court, with service continuity. What we found, then Santiniketan, that is, the school is of only Bengali, there was no school of English medium. So after going there only, he could know, then he applied at Singapore. Again, he approached this honorable court. And the honorable court passed order, your lordship can see, the order dated allowed him to join at Singapore. Your lordship can see the order dated 2/12/2004 of the writ petition.
Two
2/12/2004 in Miss case number 1585 of 2004.
Yes.
This is an application for appropriate order to allow the petitioner to join senior fellowship in Nanyang Technological University, Singapore for 2 years and to direct the opposite party 2 to 3 that in the event of success in the writ petition, they will allow the petitioner to join in his former post of professor of computer application in Utkal University. It is needless to reiterate that similar order has already been passed on 26/3/2002, Miss case number 3543 of 2002, when the petitioner desired to join Vishwabharati University, and thereafter on 19/9/2002, when the petitioner sought for a leave of the present nature to join the same university in Singapore. It goes without saying that when the similar order has been passed in similar two occasions, we observe that the petitioner is at liberty to join senior fellowship in Nanyang Technical University, Singapore, and in case the petitioner success in the writ petition, the opposite party number 2 and 3 will allow the petitioner to join in his former post professor. And the petitioner, some of the for reasons for non-cooperation of the university for a long time, they did not. The order speaks for itself. Thereafter, when the interim order was passed at the time of admission, the then Honorable Acting Chief Justice Justice R.K. Patra was there. And on the next day, Justice Bal Subramaniam joined as the Chief Justice. And after 3 days it was listed before him, he gave a very short notice. I mean, they had adjourned to give the counter. 3-4 days within a week, around 4 days there, which the order said reflects. Because there was a lot of illegalities, this thing, they did not cooperate, they did not produce the file, they did not file the counter. Then the file went to the, as it says, the court storage, and ultimately the disposal in 2001. So that is why in view of this order, he could not have come because of that the order that in case it is allowed, he will come. Thereafter, he continued there. And because he wanted to come back, then he arrived. And before the superannuation, then he filed a petition before the Honorable Court that I may be permitted, I have come. Till now, the petition is not disposed of. Because listing was at that time, it was very a great problem. Even now, I have given 10 memos to list this case. And I mentioned thrice before the deputation twice and the register twice, 4 times. And then only this was, first of all, they were not able to decide where the petition will go. Well, wherever it will go, you list it. You should respond to my 10 to 11 memos.
Okay, sir, it has been listed, so.
Thereafter.
So I have understood your case.
And here.
So you again, no, sir.
Still to a matter.
Sir, please. Sir, you came back from Singapore and joined.
Petition.
You joined.
And the Honorable Court again, little bit it took time. By the time the final judgment, what your lordship passed, at that time my superior generation is already.
So now I would like to know what was.
They are not paying pension. I am entitled.
No. Between that period, where you paid salary?
No, the salary cannot be paid because I was receiving the salary. I am not claiming salary.
Okay.
My service continuity is there because of the interim order.
So you are only claiming pension. From which date to?
Only pension and the retirement benefits.
Obviously. Who date to set up? Retirement date. Because
I joined in the year 2000 as a government servant in 18 to 1981. My service continuity will be counted till the date of my superannuation.
Superannuation date is?
Superannuation date is my lord 2000.
Because this order says that he has retired from service on attaining the age of superannuation.
During pendency of the writ application of yes. During pendency of the application, I have retired.
So, all right. What is the compliance affidavit? They have filed some compliance affidavit.
This matter was last listed, my lord, before Justice Honorable Justice M. Sahu on 16/12/2021, and the matter was heard at length, and it went to such an extent that he became. He said that first we pay 50%, then you come tomorrow. And thereafter the bench did not function. And waiting that it will come before him because he had also issued incidentally because the petitioner was online and he showed a symptom of thought. But the Honorable Judge became annoyed and directed to give him his program. No, I thought that the court will list before him, before Justice Howe. So the matter could not leave from December 21 till today, in spite of my repeated memos so many times. So thereafter, the supervision is there to calculate. My lord, this is 27th. This is.
The petitioner has been asked to file a show cause.
They are not filing so called.
No, the petitioner has been asked.
Yes, that I have submitted.
You filed a show
Yes,
cause.
yes. It was only just a protector, just wanted to say something. Probably he thought that since I am on the line, he may talk to me. But because it goes to both the places.
That will accept.
It's a silly matter.
That we will accept. So pension, I just want to know the dates. Anyway,
My lord.
what is the complaint affidavit that they have given? They filed a complaint affidavit.
Usually no. Nothing.
No, they filed a complaint affidavit.
No complaint which they said that when I demanded you pay the pension, they said that you work for 5 years and some months. The duration in which they have worked, but the law says it should be calculated from the date of my government beginning from my government service, that is from 81.
No, let us then hear them. What is the complaints?
That complaint is said that the order annexed to 4, your lordship can see.
Annex
Page 48. You also got it?
Yes.
He was appointed Professor PG Council through open selection and joined as 22-3-87. His appointment was challenged in the Honorable High Court of Orissa in OJC number such and such by Competition Department. Subsequently, by direction of the Honorable Chancellor, his appointment was cancelled by order number such and such. Dr. Mayor challenged the termination order of the Honorable High Court, OJC number such and such, and the court gave an interim order not to terminate his service till 12/12/2001. Accordingly, by the order of the Vice Chancellor, his service was restored till 10/1/2002, and again it was extended to 10/2/2002 by the order of the Honorable Court. Consequent upon his appointment as Professor Vishwabharati, Dr. Meher was relieved from the university from 27/3/2002, pending finalization of lien. After the Honorable High Court by order dated 2/12/2004 in Miss case number such and such, observed that Dr. Meher was at liberty to join senior fellow, which I placed before Lordship, University, or joins his former post at Utkal University. Because after allowing permit, Dr. Meher never returned and joined the post in the university. How can I return? By the time it was disposed of, I had already attained the supervision, and before my age of supervision, I had approached the Honorable Court. At the Honorable Court, because of that, my miscase took up the main matter and disposed of. And by the time it was when it was filed, I was within the age of 60. But when we were disposed of, I had already at the age of supervision. So
yes,
the total qualifying service of this is 5 years. This is something absurd. 259, 260 says that my entire service continuity, I got all the increment and everything from government college to reader at Barampur. Thereafter, here it comes. Your lordship knows if somebody is a government service and continues, even if he works in open selection university for 1 year, 2 years, he is entitled for full pension from that institution.
No, but you retired on superannuation from which institute?
No. By the time the petition finally disposed of, I had already crossed 60.
All right, then you were in Singapore.
Before 60, I had come before 6 months or 8 months. Before I come, since the order is this, and in case it is allowed, I will be allowed to join. Your lordship may hear the matter. And by the process, because of the non-cooperation of the university, the process of hearing took place and it exceeded my age of 60.
No, but there is an order 2/12/2004 in that writ application, which says that you are at liberty. We observe that, and in case the petitioner succeeds in the writ application, proposition number 2 and 3 will allow the petitioner to join in his former post.
Yes.
So you never came back from Singapore.
I could not have come because of the order.
You retired from that place.
No, I was
I mean, you attend the age of superannuation.
contractual wage. I could have continued. I can continue, my lord, with all respect, anywhere in the many places in the world. But I want to come back to my own country, and because of this order, the petitioner Singapore, and in case the petitioner succeeds in the writ petition, the opposite party number 2 and 3 will allow the petition.
So did yes, Mr. Das or whoever else? No, here as it appears the court has protected his lien.
No, he is not the university council is there. University for university. University is Mr. Great Bijadas.
Oh, then sorry.
Great.
I cannot hear this matter. I'm sorry.
Probably he is there for that reason. He is absent.
I'm sorry, I'm concerned, I will be concerned.
Probably for that reason, he is.
I thought the state is appearing so.
State is the wrongdoer. Wrongdoer.
After seeing this, I was thinking that she may not appear, may not hear it.
But your thinking should be louder. Your thinking never becomes louder. Unless and until it is, giving sound with bombs, the sound, the thinking don't become louder.
Sir, I cannot say anything on that.
Then it is for him to say.
No,
And for his consumption.
I'm just observing. So I'll direct it to be listed before any other bench, since Mr. Das is appearing.
Man.
Are you sure Mr. Das is appearing?
Yes. Last year it was there. Mr. Bika Das, Vijay Kumar Das.
This matter
Name
before
also,
another bench,
yes.
as I am concerned. Hello? That's all.
In fact, you were directed to pay first 50% and come back on in the December 2021.
All right.
I was also surprised how no sound is coming.
I did not well. I had not seen it.
No sound is coming from Mr. Das, but I didn't know that your lordship is concerned, but I thought that Mr. Das should be there and he should have at least interfered 4 or 5 times. I was surprised that why there is no interference. Because I wanted to say, because nowadays many times this overlapping is there. It is creating a lot of headache and also misunderstanding. If somebody is on his legs, suddenly someone is coming and creating sound, this thing, that thing, contrary to the facts, contrary to this. So it's becoming very difficult to digest at this age.
Yes, I
I know
don't
we are committing also similar type in our young age, but we have been asked to keep quiet immediately by the bench.
Yes, I don't
Now one of the benches are saying, if somebody is on the next and is not being asked by the court, if he stands up, there is serious begging from.
My lord, on behalf of Mr. Basile Pujari, I am asking
Bit
the
soon.
opposite party husband.
These matters are normally when I release it, it will be immediately released.
May I plead your lordship? On behalf of Mr. Basile Pujari, I am appearing for the opposite party husband.
My lord, I am for the petition of wife, my lord. The matter fixes for the final hearing today. for
My lord,
the
on the last occasion, I have already informed that my client is ready to go for mediation.
Let me submit, my lord. My lord, for the final hearing, the matter is that the wife filed this CRPC application that transfer of the MAT proceeding from the court of Borough to family court Borough to Jharsuguda, my lord.
That's what, yes.
My lord. And there is and my lord, here in this case that the marriage solemnized on 2017.
So this is for final disposal because on the last occasion also that she said that our client is not ready for mediation.
Well, I am prepared for the last occasion. I forgot to file the counter.
You filed? What counter transfer application? Counter
Let me submit.
And I am serving also the petition.
Counsel for the opposite party husband files objection affidavit in the court. After serving copy on the other side, the same be kept on record. Yes, what are you saying?
Mine.
Transfer from Borough to Jharsuguda.
Mine.
What is your objection?
My lord,
First of all, what is the reason why on what ground are you seeking
The
transfer?
reason, my lord, like that, the petitioner wife is not working. She is completely depends on her brother. Her brother is also having a family. The sister is an overburden. And my lord, there is a distance of 100 kilometers. There is no male member. The brother is already occupied for his work. There is no male members in the family to accompany her. And my lord, the BB case is also pending in Jharsuguda, my lord. In that light, I am also coming with a decision of Honorable Apex Court that while considering transport petitions in country like India, the wife's convenience may kindly be taken. I am giving that.
There is also a decision that wife's convenience will not always be taken.
My lord, when
I have rejected
my lord,
probably on the last week. Why are you interfering? There is the habit of interfering, I say, fine.
sorry.
Repeatedly. Last week I have passed an order rejecting an application for transfer on behalf of the wife. देखिए ऐसे objection डाल रखे पहले से जुड़ा file question. And these days the virtual mode you can always appear. Who has filed this MAT case?
Husband.
You are living at Jharsuguda.
My
You also filed a case against them in the Jharsuguda police station.
Yes,
My lord, that is a matter of 2019.
Yes.
When the husband already dragged the ସେ ଆସିଥିଲେ ଯେ ଆମକୁ ନିଅନ୍ତୁ ବୋଲି ସେତେବେଳେ ସେ ତାଙ୍କୁ ବାଡା ବାଡି କଲେ. From that date on today there is no ତାଙ୍କ change of mind କିଛି ହେଇନି.
Yes.
First of all, my lord, FIR was lodged on 27/11/2019. Then the mat case was filed about 13/9/2021. When his OP received notice 41A CRPC from Jharsuguda PS on 21/12/2009, he and other family members appeared at the police station. At that time, the brother of the wife and his antisocial colleagues reached there and threatened this OP. That's why the present OP fears for his life at Jharsuguda.
Do you admit that she has also filed a domestic violence case at Jharsuguda?
Yes, madam.
And you must be appearing in that case also?
That I don't have any instruction. Sambalpur will be convenient for both the parties.
Yes, what do you say?
My lord, the wife
Sambalpur is 25 kilometers from Jharsuguda and 50 kilometers from Bargarh. Not even 50. 50 kilometers कितना हो? What do you say? If both parties agree, I can direct the proceeding to come to Sambalpur.
Jharsuguda is convenient.
No, Jharsuguda is what you are claiming. Jharsuguda,
Right.
Sambalpur, there is hardly any difference. 25 kilometers. 25 kilometers, and you can also appear virtually. Both parties can appear virtually. And the court will not insist upon your personal attendance on every date,
Right.
unless it is absolutely necessary. And you being the, what are you doing? What is your profession?
Bank
Bank employee.
Bank employee.
Yes.
Yes. So as between you and the wife, obviously you are in a better position. I'll permit you, I'll transfer it to Bargarh, I'll permit you to appear virtually, and that your physical attendance will not be insisted upon unless it is absolutely necessary. That's all.
Hello, Sambalpur will be convenient. Actually,
Sambalpur, she has to come. And there is one case already running at Jharsuguda. So one at Jharsuguda, one at Sambalpur, one at Bargarh. I'll allow it. This transfer application has been filed on behalf of the wife of the opposite party for transfer of MAT case number 67/63 of 2021 from the court of Learned Judge Family Court Bargarh to the court of Learned Judge Family Court Jharsuguda. Said case was filed by the husband, isn't it?
Mine.
Has been filed by the husband under section 13. 13(1). Under section 13(1) of the Hindu Marriage Act for a decree of divorce. Stop. It is stated that the petitioner and the opposite party, having married on 4/5/2017, have been residing separately because of serious domestic discord. So, as such, the petitioner is residing in her father's house at Jharsuguda, as she has no source of income. Stop. Further, she has also filed a case under the domestic, under PWDB Act, under the Protection of Women under the Domestic Violence Act, being, what is that case number?
207
of 21. 207 of 21.
No, the DB, DB कौन DB मिस केस नंबर कौन लिखा है इससे? DB मिस केस number 207 of 2021 in the court of Learned SDGM. No, family judge. At Jharsuguda. She therefore, it is therefore contended that it would be difficult on her part to attend to the case at Bargod. Well, counsel appearing for the opposite party husband has opposed the prayer for transfer, mainly on the ground that earlier, JMFC Jharsuguda, 207 of 2020, JMFC, CMC, DB miscase, CMC for mainly on the ground that earlier that the brother of the petitioner is an antisocial, for which and an FIR was lodged against him, against the husband on 27/11/2019. The husband has also received notice under section 41 A of CRPC from Jharsuguda police station, and pursuant to which he, along with others, had also appeared at the police station. On that date, the brother of the petitioner and other antisocials threatened him of dire consequences. As such, the opposite party husband apprehends danger to his life if he visits Jharsuguda. After hearing land counsel for the parties.
Sorry to interrupt, my lord. After that, one FIR was lodged on 13/1/2020 by the father of the husband.
So, you have not written. It is also submitted that after that incident, another FIR has been lodged against the petitioner husband by the father of by the opposite party husband by the father of the petitioner. Yes,
Father of the opposite party filed by the FIR was lodged by the father of the opposite party.
You have not brought it, you are not clear also. In course of hearing, it is brought to the notice of the court that the opposite party husband is working as he is a bank employee, no?
Yes,
He is a bank employee
yes, ma'am.
posted at Burger. This court finds that a proceeding under PWDB Act is already pending at Jharsuguda. The MAT case, which is sought to be transferred, appears to have been filed after filing of the domestic violence case. As between the petitioner and the opposite party, it is obvious that she being a lady without any income, it would be difficult on her part to travel from Jharsuguda to Bargod on the to attend the case, attend to the case. On the other hand, it would not pose much difficulty for the opposite party husband to travel from Bargod to Jharsuguda. That apart, there being availability of the facilities to appear virtually, this problem can be easily addressed. Stop. Taking into consideration all the other facts, I am inclined to allow the prayer for transfer. It is directed that proceedings in MAT case number 67/63 of 2021, pending in the court of Learned Judge, Family Court, Bargod, shall be transferred to the court of Learned Judge, Family Court, Jharsuguda, for disposal in accordance with law. Stop. It shall be open to the opposite party husband to move appropriate application before the court below for permission to appear through virtual mode. Stop. If such application is filed, the same shall be considered in accordance with law. Stop. Further, the court below shall not insist upon the personal attendance of the parties unless it is absolutely necessary for for proper adjudication of the case. Yes.
Obliged.
Item number 13.
I please, Your Lordship. The batch of cases have been listed.
Batch case on behalf of my senior Mr. Jyotirmoy Gupta, WPC 15082 and by 2020 and WPC 21256 by 2021. The consent has already been handed over to the petitioner and the name will be deleted by.
It is there. It has come in the list today.
Yes, my lord.
Yes. 15082 and 256.
15082 by 2020.
Any other counsel has been engaged? Has any other counsel been engaged?
No, my lord. I already handed over to the petitioner. So
No. I'm asking you, after you have handed over the brief, are you aware? Has anybody been engaged?
I don't know. I don't know.
All right, I'll hear the first matter.
Yes, yes.
And these two matters, I'll ask the
I
I'll ask the office to find out if anybody has been engaged.
Yes. Well, I think the first matter that will be covered the other matter which my non-fellow has appeared.
That this technical difficulty.
Yes.
So should we call it next week then?
I respect, call it, I'm just showing you what is the limited question.
Yes.
As far as we are concerned. If also turn to say 16, this is the advertisement.
This is 2930.
First matter.
Yes.
Matter.
Yes.
Annexure 2 is the advertisement dated 36/2018. What's you get it? Yes, at page 16.
Yes.
It is a district of Subarnapur. You will also will see number of vacancies 19 number, scheduled caste 5, scheduled tribe 14, 33% reservation for women candidate out of total vacancies.
That is all.
That's right, sir. Sir, let's come to page 20.
Page 20.
Page 19, of course. 19. In India, vernacular. This is the merit list which was prepared.
That's right.
That is on 17/1/2009. We all these petitioner, they are scheduled tribes, good numbers of petitioners. In the first case, scheduled tribes. They offered their candidatures.
Scheduled tribe is five vacancies.
Yes, there are 5 vacancies. 5 vacancies scheduled caste and scheduled tribe is 14.
Achha.
And you also come to page 20, the petitioners were selected. Even in fact, the petition number 1, Surat Swan is serial number 3, and Lakshman serial number 7. Likewise, serial number in scheduled caste and scheduled tribe serial number 13 and 21. We all have been selected. The whole problem is no appointment letter was issued. So we approved this honorable court. This honorable court directed to consider the representations. Now the collector has considered the representations, said they have been selected, but we are not in a position to give them appointment because of the interim order passed in the second case, 13017/2018. And what is that interim order? Interim order is subject to the outcome of the final result of the writ application, any appointment. So now, this is way back in 2018. And our selection has been made that 2018 guideline has been given by the state in their counter. On the basis of that guideline. This is a district, not a district cadre, it is to whole state. And in fact, total 109 number of posts, but so far as the Subarnapur district is concerned, 19 posts there.
So they say that that soon after
the opposite parties, state have support my case, saying that they have been selected, they are found in the merit list, but we are not in a position to fill up the vacancies, not to give appointment to the petitioner because of the interim order.
What was the interim order passed?
Subject to the outcome, we must look to that second case.
So that is a no cause order.
That is a no cause order.
That does not stand as a bar.
Right, sir. That is exactly, perhaps you ask the state council, they can see.
I not kindly see interim order passed.
Previous year, 13017.
No, I am the petitioner in that particular case.
In the other case, where the interim order has been passed.
Where the advertisement in question.
And date
Interim order is dated 26/7/2018.
26/7/2018.
That is prior to the last date of making application even. And the entire has been delayed by the High Court while passing that interim order.
So, if any application,
we will see the
final order. I don't.
Sir, depend upon the final outcome.
The wrong submission has been made by my learned senior. I have not
I'm not saying so. You'll also see the entire order. Under what backdrop that interim order.
Yeah, that I will consider, that I will
That
consider.
is also okay. This is my solution.
So, you, who are you? You are also one of the successful.
My lord, what has happened, my lord, as you were saying,
Let me finish.
Yes.
So far, you must permit me. So far, the petition in the other case is concerned, he is not selected, even he is not the applicant. According to him, he has challenged the advertisement that because all these vacancies, how can it go to the scheduled class or scheduled tribes reservations? And what I find from his writ application, in the writ application, he refers to a circular of 2006, saying that it is one Gram Panchayat, it was in Gram Panchayat one post, so there cannot be reservation act will not be applicable. And he has referred to another 2013 also. But so far 2018, which has been annexed in the counter affidavit by the state, there is a guideline which has been framed by the state government. On that basis, the advertisement has been made. If you also look to that 2018, that is at page, and we have not challenged this 2018, that is at page 6 of the counter. 6/4/2018. Annexure as annexure A by 2.
Yeah, comprehensive guideline.
Yes, sir. This is on 6/4/2008 comprehensive guideline for selection of engagement of Gram Rozgar Sevaks under Manrega. If you also will turn to, I'm not trying to take your more time. Also, state will come to page 11, in page 11, gradation list.
Yes.
Preparation of financial gradation list. Gradation list of Gram Rozgar Sevaks at the district level is to prepare by the collector and CEO, Jila Parishad, the district taking the date of joining the post of Gram Rozgar Sevak consideration, provided further in case of date of joining of two so and so, the provisional gradation list should be illustrated in writing objection from the so and so, 30 days publication, 7 days written debate. Next is the transfer. The post of GRS is transferable in nature and within concerned district. The collector cum CEO, Jila Parishad competent transfer the GRS from one Gram Panchayat to another within district. That means it is inter-transferable from one district to other and also within district that can be permissible. So it is district now category. Now, the whole thing is we have been selected way back in 2018. Now it is 2024. Because of this interim order, the state authority, they are not taking a risk.
But one point of law, since he has raised it and which you have also said, 100% reservation.
That's whether so far as this aspect is concerned, whether it will be applicable here or not. You also look to the counter filed by the state. The state has filed a counter. That is at page paragraph 5. The multipurpose assistant, namely Gram Rozgar Sevaks, GRS, are engaged on contractual basis in each Gram Panchayat for the execution of the work, which is a co-terminus with Mahatma Gandhi National Rural so and so. The financial department concurred the creation.
So you are reading from which place?
I'm reading at the counter, page 2, internal page 2 of the counter.
Paragraph?
Paragraph. Wait, sorry.
Paragraph 6.
Sorry. I'm reading the same counter, but I'm reading. Sorry.
Paragraph 6.
Yes. 6. 6.
Which means that in reply to our
yes, government paragraph 1. It is humbly submitted. The total strength of GRS in Subarpur district is 109 against which only 3 scheduled castes, 18 UR, 40 SCBC, making a total of 61 number of employees who are in position. Further, 23 number of posts, that is 5 scheduled castes, 14 scheduled tribe, 2 SCBC and 2 UR are sub judice in the Hon'Ble High Court of Orissa in WPC number 13017/2008, 18 filed by Vishwaranjan Panigai versus so and so, WPC so and so, and filed by then filed by another writ application 14953 of 2018 filed by Sashikanta Sao versus State of Orissa and others, 26923 of 2017 filed by Siddhartha Shankar Pujari and WPC 26926 of 2017 filed by so and so. Another WPC 26938 of 2017 filed by so and so. As such, 25 number of posts are lying vacant. To fill up the vacancy, the advertisement for 25 posts, that is UR4, the women 1, scheduled caste 10, W3, scheduled tribe 11, women 3, of GRS was issued by the advertisement number 23/3/2021. That is subsequently.
of DRDA, Suvarnapur, on the basis of the comprehensive guideline issued by letter dated 6/4/2018 of so and so. This is the guideline on the basis of.
They're saying that probably the shortfall vacancies.
Shortfall in the regulation. That is what the government has filed by counter. Mr. Patnaik will, I think, will argue so far as his count is concerned. He will also look to para 9.
That amendment is with respect to the advertisement at annexure 1.
Yes, yes. That these were the shortfall vacancies.
Yes.
These are the 20, this is the advertisement of 2021.
19 vacancies which were advertised are shortfall.
That is the, no.
Para 9.
We have categorically stated in our last para, my lord, in that counter, my lord. Lordship may peruse that. Para number 11, my lord, interpretation 4.
You have referred to the subsequent advertisement.
Yes, that is what, my lord.
No. But what even though Mr. Bharti has not argued, but I'm sure he will argue that this appears to be a 100% reservation.
That is with respect to, that allegation is with respect to the 2018 advertisement.
Yes.
That we have clarified in a separate counter, my lord, while filing a counter in that case, my lord.
Is it a shortfall? Is it advertisement of shortfall vacancies?
By taking into consideration the cadre as a unit. Clarified in the para number 8 of the counter, my lord.
It doesn't appear to be very clear.
Yes, ma'am. Para number 8 of the other case, madam.
We'll see that. So, sir, this is your case.
This is my case.
But I think I'll have to adjourn it to next week because in the connected matter,
Sir, I don't.
somebody was appearing. What do you say, Mr. Mark?
Yes, sir. Very good.
I don't. Yes, my lord. Only thing I want to submit, my lord. Since your lordship, if your lordship permits, my lord, I can say one thing. My learned senior has filed the subsequent this particular writ petition challenging the subsequent advertisement.
No. That I don't want to also press.
Party, as you lordship have said.
Transaction. You need not be made a party in that case.
No. That is what my lord. Sorry, that is what my humble submission would be. The order of the collector, which they impugn, clearly shows that because of the pendency of my case and an interim order there, these persons could not be appointed so far. That is what they say. So their knowledge about pendency of my case was very much there. Moreover, these petitioners, they have filed one IA number 141 of 2020 in my case.
No, but maybe, but how can you be a necessary party in their case?
No, even they have not made a party. These 25 vacancies about which my lawyer senior, the friend appearing from the side of the government is stating. So also the counter is stating that is not the total of vacancies available in the impugned advertisement, which I said.
All right, we'll see.
So that is an advertisement which was issued subsequently, which again ran into rough areas because of filing of other writ petitions. Other petitioners being so those cases were relatable to the subsequent advertisement and since there was an entry order containing the other case, 19 posts have been stopped. Over and above, even in the subsequent cases, subsequent advertisement where 28 posts we had advertised, these subsequent writ petitions filed by others have led to non-filling of all these posts during this period. What I understood, because since I was not made a party there, I didn't have any the opportunity to go through the counter which my lordship senior has read. My humble submission, your lordship, since your lordship was saying, what was my contention there? My learned senior has made a submission that I had not challenged that guideline. That submission of my learned senior is factually incorrect because I had already challenged that very guideline basing upon which the selection had been. So that is there. Since your lordship is
adjourning because that is the reason. Otherwise, you could have been heard.
Yes. This matter, one chapter on the one day or Tuesday, fixing a date.
I will fix it. First method
Was the advertisement?
Go to the senior counsel with
SK Samal.
with Sri SK Samal is present on behalf of the petitioner. In the connected matter, WPC is Sabu category. Sri Vishwabihari Bharti, General Counsel for the petitioner is present. You in WPC 15082 or WPC 21256, right? Submission prayer is it is submitted on behalf of Sri Jyotirmoy Gupta that the brief has been transferred from him. Office to verify if any other counsel has been engaged on behalf of the petitioner. This matter on 6th May. Sir, 6th May, yes.
My lord, can I say that the other petitions which has been referred to,
No,
will it be appropriate to call those cases also? Well, I do not know.
okay, let us hear it first. You can always do that.
Item 40.
Your Lordship, I was seeing from the list, there is another matter along with this. WPC 34074 of 2023.
Yes.
Which has come because of the endorsement made by the Honorable Chief Justice. I was going through my friend's brief. I was also a party there, where also the order passed challenging that Santilata who has where that authority that has been quashed. So I was praying my learned friend to give me a copy so that if that will be taken up for hearing, I may not press the review petition because that may solve it. I have requested him and he is going to submit. My lords may fix up any other day because both are taken together along with the Honorable Chief Justice order.
ମୁଁ କପି ଦେବାର ଅସୁବିଧା କିଛି ନାହିଁ କିନ୍ତୁ ପେଟିସନ ତ ସେ ବୋଧେ କପି ଦେବା କଥା ଯଦି
No, I will get it. Sir, ତାକୁ କାହିଁକି
I'm not the party. Only see the cause title. Because he's submitting and not submitting.
Because that is
We may take copies from different petition, but first the review petition be disposed of. It is there. What is my I have a preliminary objection.
my humble submission is it has
That he may withdraw the writ application.
No,
I don't mind that. Now, my senior is taking with due respect that my handicapness, my lord knows. I cannot speak more when my senior is there. No, kindly see the cause title of the review petition. This has been delayed for many occasions. Kindly see the because what happened, this case, one of the preliminary defects are not removed, there was an interim order. And when the interim order was there, the claim of mine, what was decided in the writ petition was disposed of despite the interim order. So what recover, necessary, withdrawn or not withdrawn, everything will depend upon that. No, I am not pressing that writ petition at present. That is an independent. That is in a different order because the other court has passed an order. That is why it has been assigned to my lord. So now kindly see the review petition.
I see that.
So now let it review be decided.
I will present my lord with that. I may not press it after going through that.
You have seen it, if not.
I have seen.
I have objection. What it is objected to my friend, kindly see my lord, what is the cost title? No, I'll do one thing. I will see the cost title, then let me place the review. No, just my lord, what I'm saying. Because this is why. So I'll just simply call it day after tomorrow.
My lord?
Day after tomorrow.
Yes, ma'am.
Day after tomorrow, with the understanding that it will be. No, let him place also today because, my lord, again, they say, let him place the review petition first. No, he, according to Learned Senior Counsel, after going through the other order, he may not be required to.
Other order is there is it is before my lord. My lord can decide also.
What happened, my lord? My writ petition was disposed. Whole idea is to, if somebody is asking for time a little bit, all right, we'll grant him time, but only one day. What is wrong? What is wrong? Day after tomorrow.
This kindly see the adjournment taken in this case.
After tomorrow.
No, I am not. Whatever the time my lord will allow, I am abide by that.
No,
kindly take note of my.
I have seen that. I have understood.
Kindly see the order sheet.
I have understood.
I have a preliminary objection to the review petition.
Yes,
taken up. And now he's saying kindly see both the writ petition is there. Let me verify the cost title. We need not to go to the other thing.
I'll record his.
What is the writ petition? Who is he? Now he is saying governing body of Santilata Mahavidyalaya. Here, kindly see what is the writ petition I have filed. The writ petition, the original writ petition against which the review petition was filed. Was he a party there in the writ petition? The writ petition, he has also given it. Opposite party was Santilata Mahavidyalaya Higher Secondary School is the party. He has not come forward. And now in the connected writ petition, again, Santilata Mahavidyalaya, that Higher Secondary School is a party. Santilata Mahavidyalaya Uitikiri, who has filed the present case, and Santilata Mahavidyalaya Higher Secondary School, it's two different entities. And everything falls from that particular word, my lord. The entire issue, if my lord will permit me, I can demonstrate.
No, that's all.
What is the illegality? That is why matter went up to the writ appeal court. Writ appeal court dismissed the claim.
The earlier matter I think in this review application, the order which was sought to be reviewed, the order which I passed, I think that was clarified. But anyway, they want to be reviewed. Yeah, that name, there were two different names.
That issue. So we will go to the delete issue. What will be there with the second case? Let him place the review petition.
All right. I'll call it on draft tomorrow with the.
They will say that I have not got that copy. Again, it will be adjourned. How many times?
I undertake my own drafts of tomorrow can become because I will collect it from my own source.
I'll pass that order. Sri J.K. Ratha, Learned Senior Counsel submits that the connected writ application WPC 34074 of 2023 may have a bearing on the review application filed by him, and that he would like to go through the order passed therein. He further submits that it may so happen that the review application may not be pressed by him after perusing the order passed in the other writ application. Yes. Stop. Sri S.K. Das, Learned Counsel appearing for the opposite party, has serious objection to the prayer for adjournment. Stop. He submits that.
So to the withdrawal of the review petition, if on the submission.
Withdraw the any kind of.
Again,
That is in the future tense. Why should we?
It is lighting in future tense. So I don't know.
I'm saying that you are objecting to the adjournment.
No, I'm also objecting that on that plea he cannot withdraw. It has to be adjudicated.
Yeah? Mr. Telephone की सीट telephone इसके दास कौन? इसके दास Learned Counsel appearing for the opposite party has serious objection to the prayer for adjournment on the ground that the matter has suffered several adjournments. Stop. On this, Sri J.K. Ratha, Learned Senior Counsel, undertakes to make his submissions positively on the next date, that is on 24th. It is made clear that no further adjournment shall be granted. Yes.
Item 15.
Item 15. None appears. None appears. No, there is no appearance for the pass over Korvati. Mr. Naik. There is no chance of settlement in this case. Petition was unsuccessful.
Unsuccessful.
From where do you want? You are the wife.
Well, I am for the husband. Well.
Yes, you want transfer.
So, is the last order?
I've seen it.
Yes.
Where do you want the case to be transferred?
Because when they both are residing in the Bargod and the Athavira district. There is
outskirts of Bargod.
There are also serving well. It is agriculture. So,
where do you want it to be transferred?
Anyway, Bargod in the Bargod.
Where is it pending now?
Not only the titular, sorry,
Bolangir. You want it to be transferred to Bargod? You are a resident of Bargod. And your wife? She is residing at Bolangir.
No, he is the servant of Bargod. It is teacher, CRC. Working as a CRC in the Bargod district.
What do you say about that?
Police station.
Totally, my hand has submitted wrong, Your Lordship. Both are resident of Godbhoga. We have constructed a house at Godbhoga and both were residing at Godbhoga. After the dispute, the wife is residing at Bolangir, Your Lordship. More than 4 years.
He says that you are serving somewhere as a teacher. My lord, what is your reply to that?
My lord, already he has moved for transfer to his job to Bolangir, Your Lordship.
But where are you serving now?
My lord, the UP school at Godbhoga, Your Lordship.
Godbhoga is how far from Bargod?
Godbhoga is between the Bargod and Sambalpur, Your Lordship.
Dullampur Bargod district. Belongs to Police station.
Othabira is hardly 20 kilometers from Bargarh. Na kitna 20 kilometers ahu kam hobo. Ahu kam hobo. The last 4 years, she residing at Bolangir. Some people are working at Gorbuga. How could he be residing at Bolangir? My lord, he's coming up and down your My lord, due to mental torture, you'll see, marriage of the year 97. I will allow it. I will allow the transfer. Then I will also permit you to appear virtually. And your physical attendance will not be insisted upon unless it is absolutely necessary. So, for both of you, it will be easier to attend to the case at Bargarh than going further. It is going to appear through virtual mode, your lordship. Your lordship. Your lordship. We must look at the convenience of both parties, not only of the wife. You are nearer to Bargarh. He is at Bargarh. But the case is at Bolangir. Both are of Gurubhaga, not Bargarh. Is between Bargarh and Sambalpur. Gurubhaga is between the Bargarh and Sambalpur. So, as between Bolangir and Bargarh, Bargarh will be closer to Gurubhaga. No. As between Bargarh and Bolangir, Bargarh will be closer to Gurubhaga. It will be easier for you also to attend. My lord, that is true, your lordship. But fact is that both have constructed a house at Gurubhaga. Both were residing at Gurubhaga. Now also the petitioner husband is residing at Gurubhaga, my lord. And the present petitioner wife is residing with her parents at Bolangir, your lordship. Last 4 years, your lordship, due to the mental torture only. Not otherwise, I am saying, your lordship. And your lordship, so far the job is concerned, due to this mental torture, he is not properly doing her job, your lordship. And she constant to file this. Yes, lordship, that has been averment in the divorce petition also, and that is my submission. And I am not at all. I am transferring it and I allow you permission to appear through virtual mode. This application for transfer has been filed by the husband for transfer of MAT case number 33 of 2023. Who has filed that case? Filed by the wife. Filed by his wife, opposite party, in the court of Learned Judge, Family Court, Bolangir, to the court of Learned Judge, Family Court, Bargarh. Stop. The application, the marriage between, it appears that the marriage between the parties was solemnized on 16/2/1997. 2 children were blessed. Two children were born out of the wedlock. Because of some domestic discord, the relationship between them became sour, SOUR, which led the wife to file a proceeding, which led the wife to file the aforementioned case seeking divorce under section 13(1) of the Hindu Marriage Act. The application for transfer has been filed mainly on the ground that both the petitioner and the opposite party wife are government servants and are working in Bargarh. The wife is a teacher working as CRCC, Gortiapalli, GARTIA, Gortiapalli UP School under Othabira block in the district of Bargarh. The petitioner, husband, is working as
a Ayush doctor, Miller.
Is a Ayush doctor
in Ambabhona, PHC.
In
Ambabhona, PHC.
Ambabhona, PHC, also in the district of Bargarh. Sri Nayak Learned Counsel for the petitioner submits that it would be difficult on his part to attend to it would be difficult on the part of his client to travel to Bolangir on each date of posting of the case. Sri Jagabandhu Sahu Learned Counsel, appearing for the opposite party wife, submits that because of physical and mental torture meted out comma, his client has been residing in her parental home at Balangir. Stop. In course of hearing, it has been submitted by both parties that prior to filing of the petition for divorce, both parties were residing at a place called Godbhaga, 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 in the district of Bargarh, by building a house. Stop. It further transpires that Godbhaga situates between Bargarh and Sambalpur. This court takes note of the fact that the opposite party wife is serving as a teacher in a school which is closer to Bargarh than Balangir. This court is therefore of the considered view that it would be in the interest of both parties if the proceeding is held at Bargarh than at Balangir. Stop. For the foregoing reasons, therefore, the transfer application is allowed. It is directed that the proceedings in MAT case number 33 of 2023, pending in the Court of Learned Judge, Family Court, Balangir, shall be transferred to the Court of Learned Judge, Family Court, Bargarh, for disposal in accordance with law. Stop. It shall be open to the opposite party wife to seek permission of the court below to appear through virtual mode. Stop. If such application is filed, the same shall be considered in accordance with law, also taking note of the fact that she is a working lady. Stop. Further, the court below shall not insist upon the personal attendance of the parties unless absolutely necessary.
Item 16. Please, your lordship.
Yes.
The wife is the petitioner, my lord. In the first instance, notice has gone to the husband, and that
Notice
is
has not
postal
been
remark
served.
saying that address he left. But he is in the self-same address and he is avoiding to receive the notice.
Where is the address?
Bisam Katak.
Bisam Katak.
And I am staying in Gurundi near Parliament.
No, the opposite party is residing in the state of Gajapati. Oh, in Bisam Katak, Raigad. Notice has returned unserved.
But he is there in the self-same address and he is taking steps.
Unserved. No, letter damaged, addressee refused. Okay, ji, addressee refused will be with the postal endorsement that within inverted comma, the letter damage, addressee refused. Though ordinarily this would amount to sufficient notice, yet in the interest of justice, let a copy of the transfer application be served upon Land State Council in course of the day, who shall ensure that the same is served upon the opposite party wife through the IIC of the concerned police station.
Wife, no, I am for the wife.
I am the husband. Through the IIC of the concerned police station, indicating that the matter shall be taken up for hearing on 13th May. Yes.
Still then still.
Was it interim order passed?
No, interim order passed.
In the meantime, if an application for adjournment is moved in the court below, on behalf of the petitioner, the same shall be considered by the court below, having regard to the date fixed for hearing of this case. Yes.
Item 17.
Item 17, my lord. To BC, my lord.
Yes.
Item 17, the state has filed an additional affidavit as per the direction of this honorable court. It needs a reply, my lord. A short reply I will file within 1 week, my lord. Your lordship may call it.
Sri P.K. Mishra, Learned Counsel for the petitioner, requests for some time to file a reply to the additional affidavit filed by the state. List this matter on 13th May.
God bless.
Item number 18. So if I may please your lordship.
Item 18.
Yes, your lordship. So if I may please, my lord. My lord, the writ petitions of the year 2000, my lord.
Before my learned friend starts, my lords, just to save the my lords time, there, my lords, my friend have given a detailed calculation sheet concerning the retirement dues and all these things. I sent it to the university. In fact, my lords, on Saturday evening, we had a detailed discussion about that matter. But unfortunately, the concerned section officer met with an accident in our front itself. We carried him there. So I pray my 3, 4 days, 5 days time so that I will be equipped up with all these things to bring it to the notice of the honorable court. And
I get my reservations, my lord, that I give it, my lord. My lord, my learned senior is there, my lord, of the year 2000. This person is now 72.
Whatever amount due,
my lord, the orders are dated
I talked with that man just at 10:30. He said that whatever calculation he made, it is justified in consonance with the law. That is what he said. Then we decided that register, deputy register, and the control of finance, we all will stay together. May not be my lord. Kali भी phone करती कली phone कला से तक ले लो देखिए.
No, this is a control matter.
नहीं
He is not the only person in the.
I'm not on the
ground on a humanitarian consideration. I'm willing to.
I pay my 3 days time.
No.
ଆପଣ କହିବି ମୁଁ ଆଉ ତ କିଛି
କରିବେ ନହେଲେ ସେ ନହେଲେ I will pass an order.
20th February.
What do you think is that matters?
ଏତେ କଣ ଫାଇଟ୍ ହେଇପାରିବନି କୋର୍ଟରେ ହେଲେ କଣ Sri S.N. Patnaik, learned DGA, files counter affidavit in the court after serving copy on the other side. You have received it just now. Who wants to go through the same? List this matter on. 6th May. Rejoinder, if any, be filed in the meantime after serving copy.
6th.
Item 20. 20 May, please.
In this case also, my lord, there was a direction on 22nd March of 2024 to file the counter, my lord. I have received the paravised comment as well as the instructions, but I had discussed with them, my lord. But before that, my lord, preparation of the counter, may I bring your lordship's notice, my lord, only one thing. Here the second appeal is maintained.
Whether Anganwadi?
Disengagement case, my lord.
If my lord, I have already filed appeal before RDC.
You have filed?
Yes, my lord. I have already filed, but they have not taken into consideration, my lord. Not till now, they have not.
This total directly RDC to take.
They have not given any number.
And
on 26/12/2023.
Simply I'll dispose of directing the RDC to if an appeal has been filed, it will be considered and disposed of early.
So that within a stipulated time.
Yes. My lord, only one thing I want to bring your lordship's notice, my lord, that RDC has not been imputed as a party, but your lordship
RDC need not be imputed as a party.
But your lordship may pass that.
Yes. The petitioner has filed this writ application with the following prayer. Stop. Para. The petitioner is aggrieved by order dated 26/10/2023, passed by the ADM, though.
12/5/23 Annexure 2 passed by the sub collector, so also the Annexure 7 26/10/2023.
So Annexure 7 has been filed by the ADM.
ADM.
Passed by the
collector, my lord. Collector.
How can the collector file?
So far, this election process is concerned, my lord. It is the ADM. But so for the disengagement portion, it is the
अच्छा, but the collector is also included. This is a case where the petitioner being engaged as Anganwadi worker was disengaged for misconduct. Isn't it? The order of disengaged being challenged in the appeal, that is Anganwadi appeal case number 4 of 2023, was not interfered with by the interim order. This court finds that the remedy of second appeal is provided under clause
10D.
10B D of the revised guidelines dated from
15/3/2023.
15/3/2023. Learned counsel for the petitioner submits on instruction that his client has already preferred a second appeal before the RDC Central Division. Central Division ही तो Central Division. Yes, Central Division. That the same has not been registered as yet. Learned State Council submits that if such appeal has been preferred, it would be registered and disposed of in accordance with law. Stop. Such being the case, the writ application is disposed of, directing the RDC. Shall we direct him or shall we grant him liberty?
Better, my lord.
Better or liberty?
Till date, my lord, they do not have any proof
Yes, yes.
with respect to submission. So it will be.
Granting liberty to the petitioner to file a second appeal before the concerned RDC in terms of clause 10D of the revised guidelines dated 15/12/2023. Stop. If such appeal is filed, time ଅଛି ନା ନାହିଁ?
So it is 16 days.
So time ପଳେଇଲାଣି. Time କେତେ ଦିନ? 60 ଦିନ?
60 ଦିନ।
ଅର୍ଡରଟା ଇମ୍ପୁଟ ଅର୍ଡରଟା କେବେ କର?
ଇମ୍ପୁଟ ଅର୍ଡର ମାଇ ଲର୍ଡ 12/5/26/10/2023।
26/10. If such an appeal is filed along with a petition for condemnation of delay, the same shall be considered by the appellate authority. Taking note of the fact that the petitioner had approached this court to challenge the impugned order, apparently in ignorance of the availability of the alternative remedy of second appeal. Yeah. If that's all. Yes.
Within a stipulated time period that may be.
Since the delay is there, stipulated time, the delay he may condone, he may not condone.
I am already filed the appeal in time. That has not been registered. On 26.
It has not been filed in time. Now you are saying it has been filed in time.
That has not been numbered.
But when I asked you, have you filed in time, you said it
Yes,
has not.
hello. That appeal I have filed in time.
Filed in the date of
26/12/2023.
26/12.
आइए
कितने दिन भीतर फाइल होगा था?
60 days ଭିତରେ।
60 days ଭିତରେ କେମିତି ଉଠୁଥିଲେ?
26/12/26/10 ରୁ 26/12।
अच्छा 26/10. It is submitted that the petitioner has preferred an appeal before the RDC Central Division cutoff on 26/12/2023, but the same has not been registered. Hello. Such being the case, the writ application is disposed of, directing the second appellate authority, that is RDC Central Division cutoff, to register the appeal and to hear the same after giving opportunity to all concerned. Stop. Further, the appeal shall be disposed of as early as possible, preferably within a period of how much time? 2 months.
I don't know. A certified copy of the impugned order may be returned back.
All right. On substitution, so being on substitution by Xerox attested copy, the certified copy of the implement order be returned.
Item 21.
Yes, item 21 on 19 March, will also was pleased to issue notice. Suspended notice the other side will appear.
2024. Notices were issued for filing of the counter by 20. But we have already filed a counter, my lord. He filed on 19th of.
Why don't you file the hard copy?
दक्षिण दे दो
Jason Patnaik, learned AGA, files counter affidavit. In court, after serving copy on the other side, who wants to take, who wants to go through the same? List this matter on 6th May. Page under if only be filed in the meantime. Good.
Okay. One plus four, I think.
I am appearing for opposite party number 4.
Cool.
In this present case, item number 21.
That will come on 6th.
Yes, keep in 6th pillar.
So item number 4.
Item number 4, why was it plus 4?
2, 3, 4. Absent.
This is a parted matter, isn't it? Item number 4. Yes, item 4, none appears. You are appearing.
No, I have open number 2.
All right, learned counsel for the petitioner is not present despite repeated calls. Then counsel for the opposite party is present. Let's this matter next week.
Item number 22.
Your Lordship. This is an application for modification order. Page 13, 14 of the IA 1478. Here, my lord, I have prayed for relaxation of the condition which was imposed by my lord while granting bail to the accused person to my lord waive and to relax the condition number 4 and 5. My lord, for to movement to a foreign country, which is Singapore, for the treatment of the son, the photographs we have.
No, he had submitted a false affidavit.
No, that I have coming. Clarification I have come.
How could why did he submit that wrong?
That is 5 crore. Kindly see, my lord. The last order was my lord. I am placing the order. Last order 37, order 37, 6/4/2024. This matter is taken on hybrid mode. Mr. Sarthak Naik, Ranesh, counsel for CBI, submit that on instruction to IU.
Mr. Naik is not there.
That done in the suffering from IU.
Mr. Mishra. Anybody appearing for Mr. Naik?
Yes, Your Lordship. Yes, I pray for a short adjournment on behalf of the counsel for CBI, Your Lordship.
No, you see, he is asking for interim bail on the ground of illness of his son and whom he wants to take to Singapore. And you have also, on the last occasion, Mr. Naik also took instruction that in fact he is suffering from eye ailment. He has already furnished cash security of 2 crores.
There was some is also wrong submission because it is 5 crore. 3.5 crore is a cash on this tier, and my lord was kind enough to grant property. That 1 crore.
So cash security of 3 point?
Cash camera 3.5 crore. The cash security in SIP of SDDF.
It cannot be. It cannot be just
pledging his house, but 5 crore is 5 crore. That has not been changed. My lord, kind enough.
Cash security and
clarification I have filed. Para 6. Para 6, my lord, kindly see. Para 5, 6, I have clarified.
Have you served copy on the other side?
My lord, nobody is there, so that is.
No.
It is a bona fide, not it's a clarification I have said. That is not 2 crore, that is 5 crore.
All right, learned counsel, Sri Mr. Learned counsel for the petitioner files a further affidavit. Let him serve a copy on the other side. Let this matter tomorrow. नहीं तब लिखूं prayer for yes.
May I pray for day after tomorrow, Your Lordship?
All right, prayer for adjournment is made on behalf of Sri Sarthak Naik on the ground of his personal difficulty. Let this matter day after tomorrow.
But that 2 crore.
In the meantime, no, I will pass that order in his presence. You serve copy on him.
Yes, I will. That is.
He has some associate here.
One is there.
Who is there? All right.
Item 23.
Lordship, person of bail ପଳେଇ ସାରିଲାଣି ଯାଇ ସାରିଲାଣି ସେ
What is the meaning of?
ବେଲ୍ ପାଇଁ ମୁଁ ଇଣ୍ଟରିମ୍ ବେଲ୍ ପାଇଁ ଆପ୍ଲାଏ କରିଥିଲି ସେ ବେଲ୍ ଅଲରେଡି ଯାଇଥିଲାଣି ଜେଲ୍ ଅଥରିଟି କହିଲେ ଲାଷ୍ଟ ଅକେଜନ I have taken time to take instruction.
You are applying for legal aid, through legal aid, yes.
Lordship.
So what ordinance to be passed here?
ସେ କହିଲେ ଯେ 23/6/2023 ରେ ସେ ବେଲ୍ ରେ ଯାଇଛି
अच्छा. So you wanted to the order to be modified. It was modified. Cash security of rupees 1 lakh.
1 lakh then ସେ 1 lakh ରେ ବି ଯାଇ ପାରିଲାନି ତାପରେ ଲିଗାଲ ଏଡ୍ ଅଫିସ କୁ ଦେଲା ଯେ ମୁଁ ଗଲା ପରେ ଯାଇକିରି ପଇସା ଦେବି ତାପରେ ମୁଁ ତା ଦେହରେ ବେଲ୍ ଫାଇଲ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଫାଇଲ କଲି ତାପରେ ମୁଁ ଅବିକା ବୁଝିଲା ବେଳକୁ ସେ ପଳେଇ ସାରିଲାଣି କହିଲେ
କେମିତି ପଳେଇବ?
Lordship has ordered for 1 lakh.
କୋର୍ଟ ତ ଛାଡି ନଥିବେ ନା?
No, madam.
All right.
So.
ସେସନ କୋର୍ଟ ରୁ ପଳେଇଲେଣି ବୋଲି
Sessions court to the will after ask for the court below to.
Yes, ma'am. Clarify. Yes.
Ms. Pandal and counsel appearing for the petitioner through legal aid submits that as per her instruction, the petitioner has already been released on interim bail as directed by this court. The court below is directed to submit a report in this regard, intimating the actual position. Place this matter on 6th May. This order will be communicated to the court below. Yes.
Item 24.
Pass over.
Item 25.
Would permitted to withdraw.
Item 26.
Not item 25, may I please, Lordship? I will be permitted to withdraw. Already withdrawn. Item 26.
Item 26.
Pass over.
Item number 27.
27, my lord, 2 weeks time, further granted to report the cash, my lord, your lordship.
My lord,
2 weeks time, my lord, further 2 weeks time.
all right, 2 weeks for the time. Yes.
Item 28.
My lord, in 27, I am for informant, my lord. My lord, petitioner is intentionally avoiding the process of court, my lord. That is between the court and the petitioner. You have got nothing to say. Yes. Item 28.
Item
28, 29, 30, and can take along along with 20 item today's list, your special list, weekly list.
तो सेता जो डका हो एटा ना हो कोन पे मॉडिफिकेशन पे
Modification ସେଇଥିରେ ବି ଅଛି ସେଇଟାରେ ଆଉ ଗୋଟିଏ ଅଛି।
ऑलराइट सो एटा किछि थाओ तो कतर से 20 टका रो से
20
डका
टका।
है ना
Item 31.
yes item 31
Lordship may not be inclined to hear this matter. Earlier, it was assigned to Honorable Justice A.K. Mahapatra. He connected this matter and connected matters.
this matter
This matter.
this
Because
is
in the connected CRL MC, Lordship refused to hear this matter and as per my instruction of my client. Lordship, here I don't have any objection.
but I have granted him bail
This case.
in this case to be April 9/35 of 2024
31 so weekly.
no
Sorry.
yes Mr. Pandit
Extension of time.
first time
First time.
2 weeks time no modification आता पूर्व राउट 24 मिनट 24 हो तो 24 मिनट है तो मतलब आज करवा 24? Sure. Next week. Next week. Next week. So item number 26. Next week. Yes. Quickly, item number 1. Yes, pass over. Item number 2.
May it please, Your Lordship. May it please, Your Lordship.
Yes.
Item number 2, the present petitioners had been released on interim bail, Your Lordship, and they have surrendered, Your Lordship. Lordship,
You have
however,
surrendered?
Yes, Your Lordship. We have surrendered.
With
and
the
we
surrender
have-
certificate?
Your Lordship, we have not been able to submit that because both the brothers are inside custody. So
You are not able.
to process with those.
Your voice is breaking.
Your Lordship, since both the brothers are inside custody, Your Lordship, there is nobody to look after them, Your Lordship. So that is why we have not been able to get the certified copies of those surrender certificate, Your Lordship.
Well, it is submitted by Ms. P. Mishra, learned counsel for the petitioner, that after expiry of the period of interim bail, the petitioner has surrendered to custody. Stop. However, the surrender certificate has not been obtained, and that she requests some further time to obtain the same. Let's this matter. 13th May.
Much
Yes.
Item 24 modification.
Item 24
Yes,
of the supplementary list.
weekly.
Weekly daily. कौन है इसे? कौन है?
সেটা repeat ହେଇଯାଇଛି para 9 should be deleted. Allow the application. Subsequently, para 9 has been 1 month interim bail that has been indicated. In 2 orders, Your Lordship, allow the last Friday 1 order and
Paragraph 9 be deleted.
public.
Item number 3.
Item 3, the petitioner was granted interim bail for 2 months, Your Lordship. Have intimated their family, and there is no instruction regarding the petitioner. But I will just 2-3 days time, I'll convince the petitioner to surrender, my lord. Just Manchans.
This list is valid till 24th.
Lordship.
This list. Okay. So you get instruction by day after tomorrow?
Lordship.
But thereafter, I'll be taking up the weekly list containing second appeals.
Your Lordship. All right. After you, I will try to convince.
Yes, yes. What convince he has to surrender?
He has.
Item 4. If he doesn't, we will persuade him by way of a non-bailable warrant.
My lord may take.
We will. Don't worry. Yes. Item number 4.
That's item number 4 on behalf of Mr. Emelinka, minus no instruction.
No instruction.
Not surrendered, I think.
Not surrendered.
Undergone.
The court below is directed to submit a report. Learned counsel for the petitioner submits that he has no instructions in the matter. The court below is directed to submit a report. Report indicating whether the petitioner has surrendered to custody after expiry of the interim bail or not. Stop. If the petitioner has not surrendered, MVW will be issued. List this matter on 6th May.
In week commencing 6th May.
Item number 5.
The petitioner has filed an IF on the medical ground, my lord. He has suffered from cardiac problem, required open heart surgery, my lord. Last second, was directed to submit instruction regarding his health issue. My lord.
Yes.
Yes, ma'am. Instruction.
He is suffering from CAD. As directed, London State Council has obtained instructions from the medical officer, District Jail, Balesore, indicating that the accused petitioner is suffering from CAD and that he is undergoing treatment. As per advice of the cardiologist of SCB MCH, Patak. The accused denied for CTVS money? Coronary?
Due to some financial issues, he has denied. But subsequently, my lord, he arranged, his family also arranged some money for which
Considering the above fact, as also the ground on which the prayer for interim bail has been made, I am inclined to allow this saying. Let the petitioner be released on interim bail for a period of 1 month.
my lord, 2 months, my lord.
1 month only likhe.
Much of
I don't know, 6.
much of
Item 6, pass over.
I don't know, 7.
This case petition is in custody more than 2 years, my lord. For the alleged offence under 20B 2C of NDPS, my lord. My lord, here in this 150 kg of ganja, petition is in local man. My lord, in this case, provided has granted well by this honorable interim bail for a period of 2 months. Kindly granted me.
Same order. Mr. Mishra. The order is Prasanta Pradhan. Good.
Loknath Pradhan.
I have granted him interim bail for 2 months.
My lord.
Same order.
They both are in conscious position, my lord. Yes, lord.
Same order.
I don't know, 8.
Disposed of, my lord. 2 months interim bail disposed.
Yes.
I don't know, 8.
Well, here, the petitioner is a truck driver, fellows.
The other side is NCV, Ms. Babita Sahu.
NCV, fellows.
She is not there.
काली की रखी supplement.
नहीं supplement नहीं थे इधर तो रहेगा पास ओवर एक रहेगा. What is the quantity?
Quantity is 400. Quantity is some 400 kgs, but the main owner has been granted bail by your lordship.
Yes.
Here,
Only 1 week time required for instruction.
Already,
your lordship's last date had called for the status of this case. What is the status of the trial?
Let us see.
Only
Let us see.
one witness has been examined.
Charge has been framed against the above. 6 witnesses are cited as, out of them 1 has been examined.
It's a good tip.
As directed, the court below has submitted a status report indicating that only 1 out of 6 charge sheet witnesses have been examined so far. Sri B.K. Padil and counsel appearing, CGC.
On behalf of Miss Babita Sahu.
Sri B.K. Padil and counsel appearing on behalf of Miss Babita Sahu. The counsel for NCB requests for an adjournment, which is objected to by the counsel for the petitioner. Let's this matter next week. It is made clear that no further adjournment shall be.
Yes, my lord.
Okay.
Item 9.
Withdraw.
Withdraw?
Yes.
No, what withdraw?
Actually, sir,
have you surrendered?
Already he is in custody. केमझर केस नंबर 9504 रे कनेक्टेड है कि उठी छी लिस्टिंग रे
बुझेला नहीं के
आइटम 9504 से पूरी सी बीच केस में सी बीच केस नंबर लेकिन उठी छी 9504 रे कनेक्टेड
दिस मैं ओपन फॉर
हां यस सर विड्रॉ को
फाइल मेमो
यस
परमिटेड टू विड्रॉ
item number 10.
We have Mr. Das, HV Das, madam. I'm submitting.
Placement of
Case are registered during the Koraput case, subsequent this matter has been taken up by the STF matter. It has been registered under section 4, charge sheet has been submitted under section 419, 420, 465, 461, 7, 468, 470, 471, 120B and 34 IPs. The main allegation against the present petitioner, my lord, he has collected the money and he has given to one, my lord, one Krishna Chandra Pradhan. There.
Yes.
Very good. He has collected money, my lord, for Department of Protect, my lord, to provide, my lord, the job and to give the license of restaurant and hotel and the license for stone kuri, my lord.
The last provision, Your Lordship directed whether his account has been freezed or not.
More than 60 lakhs.
Yes, his account has been freezed, but zero balance.
The amount was withdrawn by Kanucharana Pradhan.
They said Kanucharana Pradhan has been released on bail by the order of the Honorable Appeals Court, my lord.
Yes, where is that order?
That order, my lord. And one Bhanu Mishra also he has been released on bail. That court case. And he is an anticipatory bail.
Well, same order. Charge sheet has been filed, so yes, madam. Impugned order is set aside, appellant is granted bail in terms of the condition to the satisfaction of the trial court. Contribution Act, zero.
The petitioner is in custody since?
Since 17/8/2023.
17/8/2023.
One thing, let it permitted to correct the PS case, GR case number.
In terms of the petitioner is permitted to correct the case number appearing in the bail application in court. The petitioner is in custody since
17/8/2023.
17/8/2023 in connection with such and such case. It is alleged that that one Kishore Kumar Mishra impersonating as an RTI activist as well as a government officer was found in possession of several forged documents, including ATM cards, PAN cards, including ATM cards, PAN cards, Aadhaar cards, driving license, etc. Further, he and one Kanucharan Pradhan had joined hands to cheat innocent public and to make wrongful gain thereby. Insofar as the present petitioner is concerned, what is his role?
He has collected some money to provide bar letters like stone correlations.
Insofar as the present petitioner is concerned, he is also alleged to have collected huge amount of money from the general public. Stop. His bank account contained more than 60 lakhs being transferred by co-accused Kanucharan Pradhan. Stop. Subsequently, said Kanucharan Pradhan withdrew the entire amount. Stop. It is submitted that co-accused Kanucharan Pradhan, who are one of the main offenders, has been granted bail by the Supreme Court. Another co-accused, namely Varun Mishra, has been granted protection, has been directed to be released on bail on his surrender by a coordinate bench of this court. As per order passed in ABL appeal number 150354 of 2023. Stop. Charge sheet has already been submitted. The petitioner stands more or less on the same footing as the co-accused persons who have been granted bail. Stop. The bail application is therefore allowed. Surrender release on.
released on bail. Yes.
Connected
Connected to Kishore Kumar Mishra.
connected 12744.
No, इधर चलो एक अलग देखो मुझे ठीक देखिए इधर कौन सी the petitioner is in custody since
ମୋର 17 8 ମୋର ସେଟା ସେକେଣ୍ଡ ଟା ମୋର ଅଛି
second ଟା ଆପଣ को ପ୍ଲେस କରୁଥିଲେ
ଆଜ୍ଞା
first
ଫାଷ୍ଟ ରେ ଦିବେରେ
this no second अलग order हो कट रखता तो at order the petitioner is in custody since 17 8 2023 in connection to such and such case you got actually for first portion टा ठीक नहीं है so is permitted to correct it. Right, it is alleged that the petitioner being associated with Kanhunchorana Pradhan impersonated as government officers and RTI activists and managed to cheat several innocent persons by chakri kori going to
ଆଜ୍ଞା
by
he collected 17.40 lakhs
license to the restaurant
Kishore Kumar Mishra
by promising them to arrange license for for opening restaurant.
17 point
Stop. It is alleged that he collected more than 17 lakhs in the process. Stop. It appears that the co-accused Kanhunchorana Pradhan has been granted bail by the Supreme Court of India, considering the fact that charge sheet has already been submitted. Stop. The petitioner stands on the same footing. Under such circumstances, the bail application is allowed. Let the petitioner be released.
first one lordship possible
Same order.
both
आरटा अलग जाने के लिए सिर्फ फर्स्ट आवर को
सेकंड में तो खाली करेक्शन करियो होला
करेक्शन पे अच्छी करेक्शन पे सेकंड कर दो अच्छा रे जहां खाली डॉक्यूमेंट अनुमति देखियो यस
May I pay your attention? So directed to submit the certificate of the depositions in level 1 to Procedural 12 Miller. The evidence on behalf of the prosecution has been closed. Procedural 12 IO has been examined. Paragraph 19, 498, 304 with 302 Miller.
Who are the main witnesses?
Hanging Miller.
Who are the main witnesses?
Miller.
PW4 informant and PW10 father manner
PW4. Let us see PW4.
PW10 mother, PW11 sister-in-law.
Four is the
Sister-in-law.
no PW4 is the brother.
Brother.
informant
The look on that he is the husband of my sister.
informant is the
Yes, of hanging Miller, there is no external injury. He was serving as a railway contractor on that day. It's not there, Miller.
Her dead body was found in hanging condition, but foot was touched.
Yes,
To the bed.
that was
Hanging
denied
condition, but
by
foot was touched to the bed manner.
That the lordship can see answer 12 Miller. that was,
Second page.
Not
Well, let me just go through the
Manner.
the evidence of IO, your lordship. Can you see?
I am saying. So find out the inquest report.
Case diary is not available, madam. Only supply.
No, he says that I saw that deceased was hanging from a fan.
Yes, ma'am.
In a napkin, man, gamucha. Given with the bhara. And her knees were touching the top.
Touching-
The legs were folded and blood was oozing from the feet.
Case diary is not available. The deposition purpose.
This allegation regarding dowry torture. Yes, it is there. You wanted me to see the IO's deposition?
IO deposition.
Yes, I'm seeing.
My lord, paragraph 19. The broken log camp was inside of the room attached on this place. I have mentioned in the inquest report my opinion that the cause of death of the deceased seems to be hanging. Then, my lord, paragraph 26. No, that's it. It is a fact that Procedural 10 has not stated before me that the knees of the deceased were touching the cot and the legs were folded, and that from the scenario, she came to know from the deceased that deceased has been murdered from bullet motorcycle. Then paragraph 28, my lord. It is a fact that Procedural 11, Procedural 10 is the mother, my lord, Procedural 11 is the sister-in-law. They came both after hearing from the middle brother that she has committed suicide. Procedural 11 has not stated before me that the knees of the deceased were touching the cot and the legs were folding and the blood touch and stain were on pillow, and that they were two cobras under the.
All right, the key. I want to see the inquest report because he says that he was the IO. He also says that he had removed the. He was present when the dead body was taken down. That is what he says. I held inquest over the dead body in presence of the executive magistrate, scientific team, and the witnesses. The dead body of the deceased was removed from its hanging position. So, inquest report is very important. That is one part. Second part is there is clear evidence regarding dowry torture, Mr. Mishra.
Everybody says.
And another thing is that what is your explanation regarding her death?
I was working in Bhubaneswar under a contractor, railway contractor. I was not present on that time. After hearing that she died of hanging, I came back to
Plea of alibi.
Village.
Plea of alibi you have taken. Plea of alibi.
Alibi, they have also stated that after the incident.
Let the inquest report come.
Yes.
After hearing the counsel to the petitioner, I will control and counsel to the petitioner files certified copies of the depositions of witnesses. Stop. The same be kept on record. After hearing him for some time, this court is of the view that the inquest report needs to be produced. The State Council is directed to produce the entire case diary, including the inquest report for perusal of this court. Let this matter in this week commencing 6th May. Yes.
Okay.
Item not 12. May I figure? Offense on 302, 201, 30 per IPC, petition of custody since 3/10/2023, my lord. One, my lord, one of Vikram Narendra Singh who confessed the matter before the my lord, the statement of our nephew of the deceased, my lord. I read the statement of the Bipin Baral, my lord. ମୁଁ ବିପିନ ବଳ ସଂସ ଆପଣଙ୍କ ଆଗରେ ବୟାନ ଦେବାକୁ ଏଇକି ଯେ ଗତକାଲି ମୋର ମଉସାଙ୍କ ମୃତ୍ୟୁ ଖବର ପାଇକି ମୁଁ ତାଙ୍କ ଗ୍ରାମ ଝିଣ୍ଟିକାପଲ୍ଲୀ ମୋ ମା ଓ ବାପାଙ୍କ ସହିତ ଆସିଥିଲି। ଆପଣମାନେ ଗତକାଲି ଘଟଣାସ୍ଥଳରେ ତଦନ୍ତ କରି ଫେରାର ଥିବା ମୁଦଲା ମାନଙ୍କୁ ଖୋଜୁଥିଲେ। ଆଜି ସକାଳେ 2 ଜଣ ମୁଦଲା ଧରିବାର ଖବର ପାଇଲି। ମୁଁ ମୋର ଆଜୁ ଜଣେ ଭାଇ ଜିତେନ୍ଦ୍ର ଜଣା ବାଣପୁର ଥାନାକୁ ଆସିଥିଲୁ ଦେଖିବା ପାଇଁ। ଥାନାରେ ଆପଣ ମାନେ ଆଗରେ ମୁଦଲା ବିକ୍ରମ ନରେନ୍ଦ୍ର ସିଂ who confessed the matter before. ବିକ୍ରମ ନରେନ୍ଦ୍ର ସିଂ ଏ ପ୍ରେଜେଣ୍ଟେସନ ମୁଁ ହଉଛି ଗଙ୍ଗୁ ଆଲିଆସ ଗଙ୍ଗାଧର ପଣ୍ଡା ମୋ ନାଁ। ମୁଦଲା ବିକ୍ରମ ନରେନ୍ଦ୍ର ସିଂଙ୍କୁ ପଚାରିବାରେ ସେ ତା ସ୍ୱଇଚ୍ଛାରେ ବିନା କୌଣସି ଚାପରେ ତାର ବୟାନ ଦେଲା ଯେ ଗତ 12/8/2021 ରାତି 8 ଘଣ୍ଟା ବେଳେ କାମ ସାରିକି ତାର ଶ୍ୱଶୁର ସୁରତଙ୍କ ଘରେ ଥିଲା। ସେହି ସମୟରେ ହଠାତ୍ ତାଙ୍କ ଗାଁକୁ କାହ୍ନୁଚରଣ ପଇଡା ଡିସିଜ ମାଇଲ ଏକ ମୋଟର ସାଇକେଲ ଆସିକି ପହଞ୍ଚିଲା ଓ ପୂର୍ବ ଶତ୍ରୁତାକୁ ନେଇ ସେ ତାକୁ ତାର ଶ୍ୱଶୁର ବହୁତ ଖରାପ ଭାଷାରେ ଗାଳି କଲା ଓ ସେ ତାର ଶ୍ୱଶୁର ସୁରତ ଶାଶୁକୁ ଦୁଲି ମିଶିକି ତାକୁ ବାରଣ କରିଲେ, ହେଲେ ସେ ଶୁଣିଲା ନାହିଁ। ଏ ଡିସିଜ ମାଇଲ ତାଙ୍କ ସହିତ ଝଗଡା କଲା। ସେ କହିଲା ଆଜି ଜୀବନରେ ମାରିଦେବି। ସେ ଗଲା 3-4 ଦିନ ହେବ ଏମିତି ସବୁବେଳେ ଗାଳି କରି ଆସୁଥିଲା। ମାନେ ସରପଞ୍ଚ ସହିତ ମିଶିକି ପୁଲିସକୁ ଖବର ଦେଇକି ମୋ ମଦ ଧରେଇ ଦେଲ। କାନୁନ ପ୍ରଣା ବିକ୍ରମ କୁ ଜୀବନରେ ମାରିଦେବା ପାଇଁ ଏକ ଖଣ୍ଡା ପରି ଛୁରୀରେ ଚେଷ୍ଟା କରିଲା ବେଳେ ବିକ୍ରମ ହଠାତ୍ ତା ହାତକୁ ଦେଖେଇଦେଲା। ତାର ଡାହାଣ ହାତ ପାପୁଲି ହାଣି ହୋଇ ରକ୍ତ ବାହାରିଲା। ସେ ତା ସହିତ ଧସ୍ତାଧସ୍ତି ହେଇକି ତା ହାତରୁ ସେଇ ଖଣ୍ଡା ପରି ଛୁରୀକୁ ଛଡାଇ ଆଣିଲା ଓ ତାର ଶ୍ୱଶୁର ଘରେ ଥିବା ଏକ ଚାପଡ଼ ଭଳି କାତି ଆଣିକି ରାଗରେ ସେ ତାର ଶ୍ୱଶୁର ଶାଶୁ ମିଶିକି ତାକୁ ଗୋଡେଇ ଗୋଡେଇ ଝିଣ୍ଟିକାପଲ୍ଲୀ ଗାଁ କେନାଲ ରୋଡକୁ ନେଇଗଲୁ। ସେଠାରେ ଏକ ଟଗର ଫୁଲ ଗଛ ପାଖରେ ସେଇ ଚାପଡ଼ ପରି କାତି ଓ ଖଣ୍ଡା ପରି ଛୁରୀ ତାର ମୁଣ୍ଡ ଆଖି ଗୋଡକୁ ହାଣି ତା ଜୀବନରେ ମାରିଦେଲା ଓ ସେଇ ଚାପଡ଼ ଖଣ୍ଡାକୁ ସେଠାରେ କେନାଲ ଭିତରେ ପାଣିରେ ପକେଇଦେଲା। ସେମାନେ ଫେରାର ହୋଇଗଲେ। ବିକ୍ରମ ବାଣପୁର ମେଡିକାଲ ଡାକ୍ତରଙ୍କୁ ଦେଖେଇକି ମେଡିସିନ ଧରିକି ଫେରାର ହୋଇଯାଇଥିଲା। ବିକ୍ରମ ଆନନ୍ଦରା କହିଲେ ତାକୁ ଆପଣ ମାନେ ଆଜି ଧରିଲେ। ସେ ଆହୁରି ମଧ୍ୟ କହିଲା ଯେ ସେ କେନାଲ ପାଖକୁ ତାକୁ ନେଇଗଲେ କେନାଲ ପାଣି ଭିତରେ ଲୁଚେଇ ରଖିଥିବା କାତି ଖଣ୍ଡା ଦେଖେଇ ଆଣିକି ଦେବ। ତ ବିକ୍ରମ ମାଇନେ ମୁଁ ହଉଛି ଗଙ୍ଗୁଆଲେଶ ଗଙ୍ଗାଧର
What is the disclosure statement is there, my lord? 2 Chapad and 1 Bhujali has been seized on behest of 1 Bikram Narendra Singh. What is the material against this person? Material against this person, the wife of the deceased, Babita Parida. She says, my lord, relevant person I am reading. ମୁଁ ମୋର ପିଲାଙ୍କୁ ଧରିକି ପଛରେ ଦୌଡ଼ି ଯାଇ ଦେଖିଲି ଆମ ଗାଁର କେନାଲ ପାଖରେ ତାଙ୍କୁ ହାଣୁଥିଲେ। ଆମକୁ ଦେଖିକି ସେମାନେ ସେଠାରୁ ଦୌଡ଼ିକି ପଳାଇଗଲେ। ମୁଁ ପାଖକୁ ଯାଇକି ମୋର ସ୍ୱାମୀଙ୍କୁ ସେମାନେ ହାଣିକି ମାରି ଦେଇଛନ୍ତି ଆଉ ବନ୍ଧୁକରେ ଲାଛି ଦେଇଛନ୍ତି। ରାତି ଅଧିକ ହେବାରୁ ମୁଁ ଥାନାକୁ ଆସିପାରିଲିନି। ତେଣୁ ଆଜି ଆସିକି ସକାଳେ ଆସିକି ରିପୋର୍ଟ କଲି। ଗତକାଲି ଦିନ ବେଳେ ସୁଧୀର ପ୍ରଧାନ, ଜିତୁ ପରିଡ଼ା, ଗଙ୍ଗାଧର ପରିଡ଼ା ବନ୍ଧୁକ ଧରିକି ମୋଟର ସାଇକେଲରେ ଆମ ଘର ପାଖରେ ଯିବା ଆସିବା କରୁଥିଲେ। That is the statement of the wife of the. ଆଉ ତ କିଛି ନାହିଁ ତ? No, ମାଲା only that motorcycle ଯିବା ଆସିବା କରୁଥିଲେ। ମୋଟରସାଇକେଲରେ ଯିବା ଆସିବା କରୁଥିଲେ ତା ପୂର୍ବରୁ। She doesn't say anything about the presence of this person at this point. No, ମାଲା। ଆଉ any other? And disclosure statement is there and apart from that no other material, ମାଲା। All right. The petitioner is in custody since?
ମୁଁ ଆଜ୍ଞା ରହିଲେଣି 3/10/2023
3/10/2023 in connection with such and such case. The prosecution case is that
13/8/2021
informant's husband was killed.
Yes,
the husband of the informant was brutally assaulted by several persons by means of deadly weapons, owing to previous enmity, due to which he died. The principal accused appears to be one Surya Pradhan and Bikram Narendra Singh. Bikram Narendra Singh, who, it is alleged, assaulted the deceased initially at his home and thereafter near the canal while he was trying to escape from their clutches. Stop. The Bhujali, Chapad, Bhujali and Chapad, 2 Chapad and 1 Bhujali.
Yeah.
Bhujali and Chapads used in the occurrence were recovered, but at the instance of the co-accused. Stop. Insofar as the petitioner is concerned, the informant in her statement recorded under section 161 of CRPC has only stated that she had seen the petitioner and another person moving near their house on a motorcycle prior to the occurrence. Yeah, my lord. Save and except the above, there is no other material to link the petitioner with the alleged occurrence. In such view of the matter, I am inclined to allow the prayer for bail. Let the petitioner be released.
Item number 13.
May it please your lordship.
Yes.
Under Mr. Dhala, discussion.
Item 13 is your matter, Mr. Rathar. I don't think it is your matter.
I am the informant lordship.
Oh, informant. Okay.
Petitioner.
What do you want?
Petitioner.
Yes.
Under Mr. Dhala, discuss the day after tomorrow.
All right. He wants a passover. Day after tomorrow, it will be taken up.
Item 14.
21B of the NDPS Act filed. And the quantity is 19 grams, 96 milligrams. 19 grams, 90 milligrams. And is in custody since 20 of October 2020. In the meantime, charge sheet submitted. Local person. No previous case.
Local person.
Hey, local.
Salamuddin Ahmad Salim. कहीं कोड लिखा ही चीज नहीं आगर ये फैक्टर नहीं उठा है तबे हमें अनुमान करिए
से बस पूर्ण जोड़े चल नुआ पहले
otherwise you have to imagine
no matter 24 matter is there we have filed.
Yes, Mr. Mishra.
Yes, my lord. 19 gram, 90 milligram. And charge sheet has already been filed.
Yes, all right. The petitioner is in custody since
2010-2020.
2010-2023 in connection with such and such case. It is alleged that the petitioner was in possession.
Another
Petitioner and another person were in possession of
motorcycle
contraband brown sugar weighing 19.90 mg when they were apprehended by the staff of Begunia police station. They were taken to custody after following all statutory formalities. In the meantime, charge sheet has been submitted. Taking into consideration the above fact, as also the fact that the seized contraband is less than commercial quantity, I am inclined to allow the let the petition be released. Each day appearance.
Item 15.
Yes, legal lords. No, inside custody, my lord, 34 2021.
30?
34 2021. 3 years inside custody. And my lord,
Submitted some medical documents?
Yes, yes. As report.
କଣ କରିବା ମିଛ
roaming.
ଇନକ୍ୱାରି ହବ କାହିଁ ବେକାର ଦେଖନ୍ତୁ may not be within your knowledge, whatever the briefing council may have given you.
Government medical certificate.
All forged. All forged. Better to withdraw.
3 years inside custody. Only on merit, my lord.
I have granted him interim bail earlier.
My lord.
Haven't I?
Timely surrender.
He surrendered, yes. Good. Be satisfied with that.
Thereafter, your lordship.
No, he has taken a plea before this court which has been found to be false. That's all. I will not consider anything more. I am willing to pass an order. I will pass an adverse order.
Permitted to withdraw.
Permitted to withdraw.
Item 16.
May I please? My officer 20B, 26, 25, 27, 29 by NDP except my lord. And custody since my lord 1/11/2023 my lord.
Will be FIR. Sir, कौन चाहते हैं FIR कहीं?
ये my lord escort team.
Case diary is not available.
Well, up to date case diary you obtained is this matter in the week commencing 6th quarter, 13th May.
Item 17.
Okay.
May I please, yours? No, this is a case under section 376 and again with section 6.
it within 4 months. Way back on 25/8/2022. As per order passed in BLAPL number 7464 of 2022. The court below is directed to submit a report in this regard. Lest this matter in the week commencing 13th May.
Time or state is requested to produce the case diary.
Yes. State Council shall also produce the case diary for perusal of the court.
Item 19.
Fresh key.
This is the second round of the petitioner before your lordship. In the earlier round, my lord, 302 was there, therefore your lordship was reluctant and the case was withdrawn. Now, after the filing of the preliminary charge sheet, they have visited the 302 and converted it to 306.
You are the husband?
I am the father-in-law and mother-in-law.
Father-in-law
already they are in custody.
Yes.
Only charge sheet has been sent. Today they have sent, I have taken instruction. So matrimony passed over. Case diary is available.
Yes, then it will be taken up tomorrow or day after tomorrow.
Day after.
I can give the charge sheet.
He has received. He says that he has. Pass over till, because this list is valid till 24th. So then all the elections are week. This is your matter, Mr. Purohit.
My associate.
Item 20, yes. Item 20 से तो कौन से कहते yes, Mr. Man.
Modification एटा उटे main bail application थिला सेटारो कोआकिज माने जाइथिले सेपई
So that has to be seen also. ताको भी खोल दिया देखिए इटा कौन हिजे उथरे कौन हिजे देखिए
कोआकिज पर्सन सारे विलेन run test council whether they stand for same footing and your lordship has interim protection but inadvertently that was not reflected for which petition number 2 is arrested.
Inadvertently go. Answer So you have obtained the postmortem report and statement of witnesses.
The postmortem report is there that injured witness he has said 3 jana loko thile a mu tangu dekhile chini paribi. So TI parade has been conducted but TI parade ta nahi. Case diary achi but TI parade ta nahi.
What to do?
Aro order guda reflect heichi TI parade re chini chan 3 jana.
Earlier
Koteshwar.
Yeah, sir. I have asked. And next
that Lakshmi Nursing Panda with the
Niranjan, Papu and Swadhin.
Yes.
They were also identified by him in the test identification prize. So who are you? You are?
I am Chandan Behera.
Chandan Behera.
Are you by any chance named Papu?
No.
Niranjan, Papu and Swadhin.
No, they are arrested. Arrested in custody.
So Behera and one S Rajesh Rao Dora, he has been arrested.
Yes.
That's true. But what is your name?
Chandan Behera.
Chandan Behera. So your witness has not stated his name.
Not stated. Rather, Your Lordship has elaborately discussed in the order which Your Lordship passed.
You are appearing for the informant.
May I beg your Lordship's pardon? One consideration of Your Lordship I need, my lord. That is, my lord, apart from the idea that the last statement is to the wife, that is the informant. Informant said that my husband, while rushing to the hospital, he said the name of the present petitioner along with others. That Your Lordship may consider. That is enough.
No, where is that? Where that statement? You have the statement?
Yes, in the FIR we said. In the FIR lodged by the wife of the deceased.
No, who is this Lakshmi Nursing Panda? He is the deceased.
He is the injured.
Injured. The driver of the auto. According to whom? Eighth line from the top, FIR. 8th line from the top.
3 ଜଣ ଲୋକ ହଠାତ୍ ହାତରେ ଖଣ୍ଡା ଓ ଛୁରୀ ଧରି ଆମ ଅଟୋକୁ ଆଗୁଳି ପକେଇଲେ ଆମେ ସେମାନଙ୍କୁ କିଛି ପଚାରିବା ପୂର୍ବରୁ ସେମାନେ ଧରିଥିବା ଖଣ୍ଡା ଓ ଛୁରୀରେ କିଏ ପଦ୍ମ ରେଡ୍ଡି ଓ ମିଟୁକୁ ହାଣିବା ଆରମ୍ଭ କଲେ କିଏ ପଦ୍ମ ରେଡ୍ଡି ଇଜ ଦି ଡିସିଜ୍ଡ ମୁଁ ମୋର ଜୀବନ ରକ୍ଷା ପାଇଁ ସେମାନଙ୍କୁ ଡାକ ପକେଇଲି नहीं कौन 3 जन अजଣା दुर्बृत्त हमको अटकाई खंडारे आक्रमण करिवार के पद्मरेड्डी मिठुर मृत्यु हो गला
But the injured witness hardly had any scope to know the accused person because he does not belong to the issue erupted relating to siphoning of.
all right. But he doesn't name.
Minor, therefore, my lord, the informant statement may invite lordship's kind attention to FIR. Lordship's consideration.
Yes.
Only. My lord, 8th line from the top, my lord. That the wife said. এই ঘটনার সম্পৃক্ত ଥିବା ব্যক্তিମାନଙ୍କ নাম this is the knows the medical को नेबा पूर्वରୁ धीरे धीरे କଷ୍ଟରେ କହୁଥିଲେ ସେମାନଙ୍କ ନାମ ମିଲଟ ଦିଆଦି no ହଜାରିବାଗ then in the third point the present petitioner.
So 27 persons have been named while being taken to hospital in a serious condition after so much of brutal assault on every part of his body that it was fatal. It was fatal. He died.
I don't think it is both of them. The informant and this is they belong to the
addition.
It's my only neighbor. But second Miller,
they may have been involved in the as a part of the group or the part of the group with which this group had an enmity. So they have all been roped in.
They're relating to dispute over. No, second Miller, your lordship is granted some of the accused person granted undisputed, but they didn't turn off. That is the condition. And on the contrary, they're also threatening the deceased family. You will have to in stringent condition that will.
That was reflected in the also.
Granted.
That we have.
That's well, I want that.
In that case, you file a petition for modification. In those cases, you file petition for modification that will be considered.
For your lordship's cognizance, I am submitting the trial court order. They are not. These are the persons have been granted bail, and then they are demeanor this like that.
Cancellation. Individual has been issued against Dibakar, Hajari, Chinmoy.
I should
law will take its own course. Law will take its own course if they have been issued with NBW. If they are not appearing,
then the Lanet court can very well within jurisdiction to bring them.
Some others had filed a petition along with 317 also. That was also rejected, and NBW was issued.
These persons are these accused persons are filed. 317 petition, but your lordship has directed to personally present.
Yes,
in the police station, but police they are not going to the police station. On the contrary, they have threatening the deceased family, the wife in home.
All right. The petitioner appearance arrest in connection to such and such case.
Lordship, petition number 1 to arrested.
He is arrested, sorry.
Yes.
So that is dismissed as infructuous account?
Yes.
It is submitted that petition number 2 has been arrested in the meantime. For which the petition in respect of him may be treated as not pressed. The ABL appeal in respect of petitioner number 2 is dismissed as not pressed. The petitioner number 1 is apprehending arrest in connection with such and such case. Previous B Koteshwar Doraro is लिखिदंतु खाली सिनियर काउंसिल जाकर खाली लैंड काउंसिल कर दो. Same order. I think same order will do. It is Mr. Jyotirmoy Sahib लिखा है कि फ्रॉम ऑफ द इंफॉर्मेंट तो भवन शंकर दास को कर दो. Same order will do.
Hi. Until asking given all stringent condition. Only your lordship may direct the police concerned IO to strict sense of follow your lordship direction that may do well. Nothing else.
Same thing. I further
IO chat slap.
No, I have directed him.
Your lordship, I have said it. Your lordship
shall be certified by the IEC concerned court once in a month.
Your lordship already
the court below shall also monitor such fact by taking regular updates from the IOC.
Diploma, that is.
He is working as Calcutta. Every alternate day, that condition may be.
Take leave of the boy.
To appear in.
Every alternate day to Every alternate day on every Sunday at 10 a.m. Every Sunday at 10.
Regulate, your lordship has already hold the regulate, that's all, everything.
Yes.
What about the other cases?
Say alternate data खाली change करिया आपने.
Chalo से कर दो, every Sunday at 10.
Sunday.
ସେଥିରେ ବି ସେଟା ଆଡ୍ କରିଦେବେ ଆର ଗୋଟା ମାନେ ସପ୍ଲିମେଣ୍ଟାରୀ ଲିଷ୍ଟ ସେଥିରେ ବି ଆଡ୍ କରିଦେବେ ଯେ the court below is also directed to monitor ହେଲା take regular updates.
Okay.
Item 21.
My pleasure, Lordship.
My lord, kindly have a glance to page number 16.
My lord, 21, in most of the cases, today I have received the case diary. Let this matter be passed over, taken up on Wednesday. Well, in the meantime, I will verify the record.
May I say one thing? My lord, kindly have a glance to page number 16, my lord.
Well, but you heard him, he wants to be prepared.
କିଛି ନାହିଁ ସେଥିରେ ବସ୍ ମୁଁ ଖାଲି ଗୋଟେ ପଦ କହିବାକୁ ଯାଉଛି ହଜୁର ଦେଖିଦିଅନ୍ତୁ page number 16 my lord, the accused person who was named on the basis of co-accused who has been arrested, they said that they are the procurers of ganja. So from them they have procured Sashikanta Mishra along with 3 to 4 other persons who are before my lord. This is the
order ଅଛି
co-accused statement ଯୋଉଥିରେ ସେମାନେ ରିଭିଲ୍ କରିଛନ୍ତି ଯେ ଆମେ ସୂର୍ଯ୍ୟ ବୀର ତା ସାଙ୍ଗେ ଯୋଉ 3 ଜଣ ହଜୁରଙ୍କ ପାଖରେ ଅଛନ୍ତି ପିଟିସନର ସେମାନଙ୍କ ଠାରୁ ଆମେ ପ୍ରୋକ୍ୟୁର କରୁଛୁ ସୂର୍ଯ୍ୟ ବୀର has already been released on bail after going through the CD. So Sevan, except the co-accused statement, my lord, there are no any legal materials to conclave these 3 petitioners to this case.
Yes.
That in the FIR their name is not there. But I will verify, my lord.
ନାହିଁ same order. Same order କର କାହିଁର
My lord, deeply obliged.
I've seen the order passed in case of Sashikanta Mishra. Yes, sir. Same order.
Deeply obliged.
Statement the co-accused नाटा पहले.
Statement of co-accused. Ravindra Malik.
My lord,
Gunjan Mahadev Atsul and Sanjay Sonawale. Those are 2 reflected in the order sheet of.
All right. Same order.
Deeply obliged.
Connected matter.
See, 3ଟା ତା ସାଙ୍ଗରେ ଅଛି my lord. ଗୋଟିଏ
Ravindra Malik and
my lord.
Sashikanta Mishra.
My lord.
नहीं इमान दिनों को कौन अच्छा?
Same footing my lord.
ताकि ना दिखाई जिसे पढ़िए से परसेंट पढ़िए.
Kisant Biro.
ठीक है. All right. Same order.
Deeply obliged. Item 22. No.
Your lordship, the self-same FIR direct already disposed of the matter. By ABL पर 11/11/24 granted anticipation.
Yes, sir. Petition as well as some of the information. All right. Same order.
Obliged.
Item 23.
Item 23, may I please the Lordship? Allegation number 379-120B. The Lordship, at Annexer 2, co-accused was released on bail. The allegation is regarding theft of coal in a vehicle. The petitioner is the owner and was not on the spot. All right, same order.
My lord, FIR honor, my lord. The offense, my lord, for 2394, 397, 25 answer and 60D of Information Act, my lord. In the meantime, one co-accused was already released on bail, my lord. Same putting the petition was standing, my lord.
Yes.
My lord, FIR was unknown FIR.
Same order.
Come in the similar.
Same order.
25. May I please, your lordship. Offense under 52 Excise Act, your lordship. And one of the co-accused granted bail, that is at running plus 15, your lordship.
All right.
FIR against the driver. Driver was already released on bail. That is a 14700 of 23.
Yes.
So who is the present petitioner?
He is the driver, my lord. The earlier person was the owner of the vehicle.
I have simply said that the petitioner was in possession of 400 liters of ID liquor when he was apprehended by excise officials.
The petition he has
that I have mentioned, my lord.
That ABL number, he has stated that the driver has already released on bail.
No, owner. That's the owner. Pramanda Saha was the owner, your lordship. That I have mentioned in.
It is alleged that the petitioner was driving the vehicle in which 400 liters of ID liquor
was being transported. So, transported. And it was apprehended by excise officials. Stop. Surrender result.
Item 26.
Consultation 341, 294, 307, 332, 379, 506, and 34 IPs, my lord. In this case, my lord, allegation is that when the forest personnel performing his duty, some unknown persons cutting the kendul trees, my lord. When he obstructed, they abused them in slang language and assaulted by men.
Granted bail.
13570.
Yes, sir. Has this petitioner been named in the affair?
No, my lord, no, unknown.
Unknown affair against 12 to
So what is the nature of his, what is the reason for his application?
Well, it is first time it has come, but the rejection order, two co-accused persons bail application was allowed. 15172 and 13570.
It was allowed?
It was allowed.
No, on the ground that the injuries sustained are simple in nature.
Madam.
Same order?
Same order.
Same order.
Item 27.
May. Same occurrence when the two affairs were lost. Annexure 1 is the present affair, and Annexure 2 is the past affair. Two informants, but occurrence same, and allegations are same. In the first affair, only 307 has been added, and in the second affair, 307 was not there.
Produce the report.
And in similar cases, your lordship already granted bail, that is
Granted bail?
cause list. In the cause
1064 of 24.
in the cause list, number is there. Bail number is there.
No, bail number is 905.
Yes.
905 is there, but 905 is withdrawn.
Then madam 962 and 1064.
And in the connected case, against the present petitioner, that is Annexure 2, your lordships allowed the bail application, that is the ABLAPL number 1397 of 2024.
You have the copy of that order?
No.
What is that order date?
21/2/2024.
Bar kar do. ABLAPL number?
1397 of 2024.
1397 of 2024.
Or dated 21st February 2020.
Upload.
So I was appearing, but I don't know. Allegation same, occurrence same. Only 307 has been added in the present paper.
The blocking of the national highway?
Yes. Due to accident, they were blocking the national highway. When police tried to clear the blockage.
Same order.
No.
May I please, on behalf of PK Pradhan, my lord. Offense number 302 of IPC, my lord. And custody.
Case date made. In the meantime, 11 witnesses were examined. Lordship may call for the case diary and this can be directed to deposit the deposition.
Uploaded case diary, be obtained by London State Council. London Council for the petitioner shall produce the copies of depositions of the witnesses examined so far. Let this matter in the week commencing 13th May.
Item 29.
Please, your lordship. Allegation under section 363, 376, 12, 376, 3 IPC and read with 4 to 6 of POCSO Act. The accused is in custody since 10th September 2020.
before. No, you forget about that. If Mr. Sahu says that his name has been deleted from the charge sheet, then this becomes infructuous. Just obtain, I'll record his submission and you ask you to obtain this information. Right. Then State Council submits that the order dated 10/5/2022 could not be complied with, as the copy thereof was served only recently, was supplied only recently. Stop. Further, see, the DK Sahu, Lieutenant Counsel for the petitioner, submits that as per his instructions, the petitioner's name has been deleted from the charge sheet, submitted in the meantime. State Council is to take instructions in this regard. Let this matter in the week commencing 3rd May? 6th May, sorry. 6th May.
Item 31.
No, it's the matter where the Lordship may not be inclined to hear this matter. This was earlier on, my lord, on 21/3/2022. After the passing of the order, it was assigned, Honorable Chief Justice has assigned the matter to in favor of
21/3/2022. It was before me.
No, because Honorable
Justice
Justice yes, he refused to hear the matter. Therefore, it was again.
No, I refused to hear. That is why it had gone.
No. Your Lordship, in the connected matter, CRMC refused to hear the matter. So, not in this BLAPL.
Okay. So if that matter I refuse, this matter will obviously I will refuse.
That's certain.
Two CRMC.
And this was already.
There was a CRLMC.
CRLMC is not there. CRLMC are the same petitioner mirror relating to this case.
Okay.
We don't have any objection if Lordship want to hear this matter.
No. If I must see why I had recused. I have to see. I have to find out. There must be some reason why I have, isn't it?
Petition, both the cases, petitioner and his wife, connected matters.
You have
and
been
it was specifically assigned to Honorable Justice A.K. Mahapatra by.
We'll do one thing.
Yes.
Let it be passed over. I'll call the BR and I'll find out.
Yes.
Pass over for the day. Item 32.
Ready to pass over.
Item 33.
Pass over.
Item 34.
Item 34.
Item 35.
Similar case under section 302. Petitioner is in custody since 2/10/2020. Here we had near about 3 years and 6 months. Here there is no direct evidence, and out of 37 charge sheeted witnesses, 7 witnesses were examined. Therefore, this Honorable Court called for the status report. And the informant Subrakasi Chatia, who is the that mother of that deceased, she is not coming in spite of several summons. There is an order and I have the telephonic instruction that she is now residing at Kerala and there is no eyewitness and nothing only the affair was lost by that informant as if she is an eyewitness, but the 164 statement, your Lordship may kindly see, this is, she had not seen the occurrence. She only had that and all the 7 witnesses have filed the deposition copies, also saw.
Nobody has said anything.
Nobody said anything,
Yes,
that Archana Kabiri, an informant, whether they were examined or not.
Informant is not coming, in spite of that.
What has the informant said?
Informant 164 statement.
164.
Subrakasi Chatriya.
Subrakasi Chatriya. That's 164. What is the deposition of the
deposition? Informant has to Nijamas.
ଗୋଟେ କଥା ମୁଁ ଦେଖିଲି ରଶ୍ମିକାନ୍ତ ଜୋରରେ ଦୌଡ଼ିକି ନାଳ ପାଖରୁ ପଳେଇଲା।
Yes, my lord. ସେଇ ଗୋଟିଏ ଜିନିଷ ଖାଲି ଆଉ
No, this is a very important conduct.
no
Post occurrence
what
conduct.
happened, my lord?
This is admissible. This is admissible.
But so far as the
Section 8 ନା କେତେ?
evidence
Section 8 of the Evidence Act. ବୁଝିଲେ? Immediately preceding or post the conduct, post the occurrence. Motive, preparation and previous or subsequent conduct.
section.
This will become admissible. This is admissible.
But here, my lord,
She does not say that she has seen that accused assaulting. Doesn't matter. But that the accused is the husband of the lady who was killed. Why did he run away from the spot?
because my lord, what happened? This petition.
If somebody else had assaulted his wife and she was lying in a very, injured condition with bleeding injuries and all that. So naturally, the first reaction of the husband would be, which is a normal human conduct, would be to save her. Why will she run away? Why will he run away?
Same village, and here, my lord,
He has assaulted for that reason. And minor that person, two persons are there, Archana and Kaveri.
Can't say. They are
minor.
164.
Yes, my 161 is there, madam. I'm reading one. Kaveri is taken, madam.
they are not one eyewitnesses.
ପୁଣି ଏଠି ଆଉ ଗୋଟେ ଅଛି ଦେଖିଲା ବେଳେ ସେ ମତେ କହିଲା ମା ମତେ ମାରିଦେଲେ ମତେ ଡାକ୍ତରଖାନା ନେଇଯା
କିଏ କାହା ନାଁ କହିନି
ଦରକାର ନାହିଁ
here what happened, my lord, I am moving this application because of out of 37 charge sheet witnesses, only 7 witnesses examined, my lord. Since 3 years 7
ସେ ଝିଅ କଣ କହିଛି what is the
3 ବର୍ଷ 6 ମାସ ହେଲାଣି ସେ ରହିଛି ଜେଲରେ। ସେ ଆଉ ତାଙ୍କର ଭିତରେ ଅଛି ଝଗଡା ମାନେ since last 5 year deceased and petitioner are husband and wife, and since last 5 year they are separated, my lord. It is not a case that they are residing jointly or anything, my lord.
Yeah, he post occurrence.
Post occurrence, but he has not seen that. But
because the motive of the informant here, my lord, here what happened, the background of the case is, my lord, the petitioner is the husband of the deceased, and since last 5 year of the occurrence, this is the prosecution story, my lord. Since last 5 years they are separated. 5 years back, my lord, and there is a, my lord, motive of the informant to implicate the present petition because there was earlier dispute and everything, my lord. And since 4 ବର୍ଷ ପାଖାପାଖି ହେଲାଣି ରହିଛି custody, informant is not coming in spite of several summons. The lordship may kindly
below has submitted a report stating that 8 out of 34 charge sheeted witnesses have been examined so far. And that despite repeated summons, the informant has not turned up to give evidence. Stop. Look, since the petitioner has been in custody for more than 4 years.
No, more than 3 years and 6 months.
For more than 3 years, 6 months, the court below should take
lordship may interim
appropriate steps. No, appropriate steps, including coercive steps, to examine the informant, who is the first post occurrence witness to have seen the accused running away from the spot, as per her statement recorded under section 164 of CRPC. Stop. I also believe the petitioner is in custody since when?
Since, my lord, date ta hoji
2/10/20. But my lord,
I'm rejecting 2/10/2020 in connection with
interim bill I am praying.
It is alleged that the petitioner was married to the deceased and they had 3 children, but because of repeated misbehavior an assault and physical assault. The deceased was residing with her mother. So, on the date of occurrence, finding the deceased alone, taking bath in the pond, village pond, the petitioner assaulted her severely, causing her death. Stop. Having regard to the statement of the informant, as above, I am not inclined to entertain this application. I am not inclined to allow the prayer for bail. The bail application is therefore rejected. However, the court below shall do well to take prompt steps to conclude the trial, if necessary, by taking coercive steps against the non-attending witnesses, and make an effort to conclude the trial within a period of 4 months. Stop. It shall be open to the petitioner to renew his prayer if trial is not concluded within the period stipulated. Yes.
No.
36.
May I please, Your Lordship? Your Lordship, in the previous occasion, Your Lordship had directed to obtain instruction as to the economic status of both the parties.
Economic status. The child has been born, whose age is about 6 years.
Yes, madam.
PWC was examined at PW4. No, what is the economic status? Because I will, if at all I grant bail, then I will definitely ask him to maintain the child. Next week as soon as. All right, as requested by Land State Council, is this matter in the week commencing 29th April.
Item number 37. Item number 38.
Bolaram Doctor Jona. 38, yes.
38, Mr. Naik was appearing. He has requested for Passover.
If he comes, then we'll take it up.
Item 39.
May I please, my lords? Lordship, on the last occasion, wanted to directed to know what is the position regarding the trial.
Using 1 out of 3 being to have been examined, 1 was using.
So you were, my lords, 25th को fix age.
25th,
my lords.
We'll take it up next week then.
39.
This is a NDPS matter.
NDPS matter.
What is the quantity?
My lords, quantity
25
25
kg,
kg.
he belongs to Rajasthan. So what to do? At this stage, what bail?
That your lordship directed to take instruction whether the last
only one more witness remains to be examined.
Whether he was examined or not.
So he says that it is fixed to 25th. Then State Council for the petitioner submits on instructions that the trial is posted to 25th of this month.
Where that iron rod was found, that iron rod in the disclosure statement, he has categorically stated that it was found from the spot.
Okay.
ମୁଁ ଆମ ଗାଁ ଉପର ସାହିର ନାଗିମୁଣ୍ଡା ଘରକୁ ଯାଇଥିଲି। ନାଗିମୁଣ୍ଡା ସହିତ ମୋର ପୂର୍ବରୁ ପ୍ରେମ ସମ୍ପର୍କ ଅଛି। ମତେ ନାଗିମୁଣ୍ଡାର ଶ୍ୱଶୁର କୁନ୍ଦ୍ରାମୁଣ୍ଡା ପାଟିତୁଣ୍ଡ କରେ, ଅସାବେଶରେ ଗାଳି କରିବାରୁ ତାର ଘର ପାଖରେ ପଡିଥିବା ଗୋଟେ ଲୁହା ରଡରେ ମୁଁ କୁନ୍ଦ୍ରାମୁଣ୍ଡାର ମୁଣ୍ଡକୁ ଜୋରରେ ଆଘାତ କରିବାରୁ କୁନ୍ଦ୍ରାମୁଣ୍ଡାର ମୁଣ୍ଡ ଫାଟିଯାଇ ରକ୍ତ ବାହାରିଲା ଓ ସେଠାରେ ପଡିଗଲା। ମୁଁ ସେଠାରୁ ମରିଯାଇଛି ବୋଲି ଜାଣି ଲୁହା ରଡଟିକୁ ଧରି ଆମ ଘରକୁ ଯାଇ ଆମ ଘର ପଛପଟ ଛପର ଭିତରେ ଲୁଚେଇ ରଖିଛି। ଆପଣ ମତେ ନେଲେ ମୁଁ ସେ ଜାଗାକୁ ନେଲେ ମୁଁ ଲୁଚାଇ ଲୁହା ରଡଟି ଦେଇଦେବି। So it was found from the spot.
As directed, Land State Council has obtained, as directed, Land State Council, after referring to the case diary, informs that the iron rod used by the petitioner, allegedly, to assault the deceased, was found from the house of the deceased. Stop. Yes, what is the case? What other proof is there?
My lord, the FIR is unknown, but on the basis of the statement of my lord that Nagimunda and one his daughter, my lord, the daughter of the deceased, my lord, the accused has been implicated in the case, ma'am.
Nagimunda is the to whom that present petitioner have relationship with that Nagimunda. And the present petitioner also made extrajudicial confession before the Nagimunda.
Only on the basis of
On
that.
that basis, he was implicated.
Nagimunda.
Right.
ପଢିଦେଲ
ଏଇଟା ପଢନ୍ତୁ।
ମୋ ନାମ ନାଗିମୁଣ୍ଡା ବୟସ ରିଲିଭାଣ୍ଟ। ମୁଁ ମୋର ସ୍ୱାମୀ ପ୍ରାୟ 7 ବର୍ଷ ହେବ ମରି ଯାଇଛନ୍ତି। ବର୍ତ୍ତମାନ ମୁଁ ମୋର 2 ପୁଅ ଅଭିଷେକ ଏବଂ ଚିନ୍ନା ଓ ମୋର ଶ୍ୱଶୁର ତନ୍ଦା ମୁଣ୍ଡା ସହିତ ଗୋପକାରେ ରହୁଛି। ମୋର ଶ୍ୱଶୁର ତାଙ୍କର ପୁରୁଣା ଘରେ ଏକୁଟିଆ ରହୁଥିଲେ। ମୁଁ ଗୌର 2 ପୁଅଙ୍କ ସହିତ ନୂଆ ଇନ୍ଦିରାବାସ ଘରେ ରହୁଛି। ଗତ 15-20 ଦିନ ରାତି ପ୍ରାୟ 8 ସମୟରେ ଆମ ଗାଁର ପୁରନ୍ଦର ବିଶାଳ ଆମ ଘରକୁ ଆସିଥିଲା। ମୁଁ ସେତେବେଳେ ଆମ ଘରେ ପୁଅମାନଙ୍କ ସହିତ ଶୋଇଥିଲି ଓ ମୋର ଶ୍ୱଶୁର ତାଙ୍କ ଘରେ ଟିକେ ମଦ ପିଇ କଣ ବାଉଳି ହଉଥିଲେ। ପୁରନ୍ଦର ଏହା ଶୁଣି ମତେ ଫୋନ କଲେ। ମୁଁ ଉଠି ବାହାରକୁ ଆସି ଦେଖିଲି ଯେ ଆମ ଘର ସାମ୍ନାରେ ସେ ଠିଆ ହୋଇଛି। ତାପରେ ପୁରନ୍ଦର ମତେ ପଚାରିଲା ତୁମ ବୁଢା କାହିଁକି ପାଟି କରୁଛି? ମୁଁ ତାକୁ କହିଲି ସେ ଟିକେ ମଦ ପିଇ ଦେଇଛି। ତାପରେ ମୁଁ ତାକୁ ଏଠାରୁ ଚାଲିଯାଅ ବୋଲି କହି ଆମ ଘର ଭିତରକୁ ପଶିଗଲି। ପ୍ରାୟ 15-20 ମିନିଟ୍ ପରେ ପୁଣି ଥରେ ପୁରନ୍ଦର ଆସି ମତେ କହିଲା ଯେ ମୋର ଶ୍ୱଶୁରକୁ ଘର ଭିତରକୁ ପଶି ବୁଢାକୁ ମାରି ଦେଇଛି ଓ ବୁଢା ତାର ବାରଣ୍ଡାରେ ରକ୍ତ ଜୋର ହୋଇ ପଡିଛି। ମୁଁ ବୁଢା ପାଖକୁ ଯିବି ବୋଲି ବାହାରୁଥିବା ସମୟରେ କଣ୍ଡକ୍ଟ ଅଫ ଦ୍ୟାଟ ପୁରନ୍ଦର ମତେ କହିଲା ଚାଲ ମୁଁ ତତେ ତୋର ମା ଘରେ ଛାଡିଦେବି, ଏକଥା କେହି ଜାଣିପାରିବେ ନାହିଁ। ମୁଁ ଯିବିନି ବୋଲି କହିବାରୁ ସେ ମତେ ଜୋର ଜବରଦସ୍ତ ଯିବାକୁ କହି ତାର ମୋଟର ସାଇକେଲରେ ମତେ ମୋ ମା ଘର ଶଙ୍ଖ ପୋଷରେ ଛାଡିଦେଇ ଫେରି ଆସିଲା। ମୋର ମା ଘରେ ମୋର ମା ଏତେ ରାତିରେ କୁଆଡେ ଆସିବ ବୋଲି ମତେ ପଚାରିବାରୁ ମୁଁ ମୋର ମା କୁ କହିଲି ଯେ ମୋର ଶ୍ୱଶୁର ମଦ ପିଇ ପାଟିତୁଣ୍ଡ କରୁଛନ୍ତି, ମୁଁ ଏଠାକୁ ଚାଲି ଆସିଲି। ତାପରେ ଆଜି 10ଟା ସମୟରେ ରାଜେନ୍ଦ୍ର ମୁଣ୍ଡା ସହିତ ଗୋପନକୁ ଆସିଲି। ମୋ ଶ୍ୱଶୁର ରହୁଥିବା କବାଟ ଘରେ ଲକ୍ କବାଟ ଖୋଲି ଭିତରକୁ ଦେଖିଲି।
Has she been co-accused? Has she become a co-accused in this case?
Nagimunda is.
She is co-accused?
No.
How come?
He is not she is also not stated the occurrence to.
No. Whatever she has stated, it seems she had a role to play. Though not directly, but indirectly. Anyway, what other material against other than Nagimunda's statement?
Nagimunda's statement. Another one is Lipamunda, madam. ସେ ପୁରନ୍ଦର ଓ ବୋହୁ ନାଗିମୁଣ୍ଡା ଉଭୟଙ୍କ ମଧ୍ୟରେ ପ୍ରେମ ସମ୍ପର୍କ ଅଛି। କାଲି ରାତି 8:30 ମଧ୍ୟରେ ପୁରନ୍ଦର ବୋହୁ ଘରକୁ ଆସିଥିଲା। ପୁରନ୍ଦର ଆସିଥିବା ଜାଣି ମୋର ବଡ ଭାଇ କାନ୍ଦାର ଘର ଭିତରେ କିଏ ଆସିଛି ବୋଲି ପାଟିତୁଣ୍ଡ କରୁଥିଲା। ତାପରେ ମୁଁ ଆଉ ଜାଣିପାରିଲି ନାହିଁ। ଆଜି ସକାଳ 10ଟାରେ ନାଗିମୁଣ୍ଡା କାନ୍ଦି କହିଲା ଯେ ଗତ ରାତିରେ ପୁରନ୍ଦର ତାର ଶ୍ୱଶୁର କନ୍ଦାମୁଣ୍ଡାକୁ ମାରି ଦେଇଛି। That Nagimunda had stated before this person. ମୁଁ ତାପରେ ଯାଇ ଦେଖିଲି ଯେ ମୋ ବଡ ଭାଇ and that iron rod was seized from the present petition.
No clear-cut evidence.
No, only that confessional statement, that is the extrajudicial confession before that Nagimunda by the present petitioner and seizure of that iron rod.
କେବେଠୁ କଷ୍ଟଡି ଅଛନ୍ତି?
1880-20 miles.
The petitioner is in custody since 18/8/2020 in connection with such and such case. The prosecution case is that the petitioner used to visit the house of the deceased and had an illicit relationship with his daughter-in-law, Nagimunda. On the date of occurrence, on the night of occurrence, he entered into the house of the deceased, whom he found to be shouting, being drunk. Stop. Nobody has seen the occurrence. The first person to know about the occurrence appears to be Nagimunda, before whom the accused is said to have confessed of killing the deceased by assaulting him with an iron rod. Further, the iron rod was recovered at the instance of the petitioner. Stop. Save and accept the above. There is no other admissible evidence to definitely show a link between the petitioner and the alleged occurrence. Taking into consideration the above facts as also the period of detention in custody, I am inclined to allow the prayer for bail. Each the appearance.
Item 41.
Pass over.
Item 42.
42, Your Lordship, the conducting counsel has some personal difficulty. He had called me in the morning and he is not in the court also. I humbly pray for an adjournment on his behalf.
Next week. Let's pray for.
Obliged.
The petitioner will look.
Item 43.
Pass over.
Item 44.
With leave of your lordship, my lords. So I am accused of driving 250 kilograms of ganja, my lords. The only driver. The allegation is that the materials were seized from the storage compartment of the vehicle, and I was unfortunately the driver for that particular.
Why unfortunately?
I am only
unfortunately because your misfortune started when you were caught. Otherwise, it would have been a very, very fortunate event. No, you would have sold the entire 250 kgs of contraband.
Maybe that might
and you would have become even wealthier.
I was only given an assignment because the regular driver was on leave.
You have been granted interim bail once, I have seen. And you have surrendered custody.
Because of my father's illness, now he is also on the deathbed. I never know at what time I will be hearing the last word.
A person whose son commits such crime, naturally he would be.
Obviously, but he was prior to that, he was suffering. And my only
his suffering may have been aggravated by your control,
my lord. That these things happen. So father is a father, my lord. Your lordship knows how can he will sustain.
Yes.
But still then he is
interim bail, Mr. Das?
Your lordship so pleases, I will be obliged.
You were granted interim bail?
I was granted an interim bail and I did oblige your lordship's order, keep myself confined to your lordship's order. I surrendered 3 days before.
Just 3 days before?
No, on it was there, 17th I surrendered.
The interim granted
20th. Yes. That your lordship sees the order dated 18/10/23, order number 3.
Yes.
They are keeping in view the exigency and emergency of my father's health condition. Your lordship were pleased to grant me for an interim period bail till 17th and I surrendered on 14th. And there is no antecedents I will suppose my friend would give. I have never committed such
huge quantity, 250 kg.
250 kg. But I am the driver only and others are abscond.
Conscious person is there. So 37 is bar.
Not a single, I know my reservations, my lords, but nothing found from the driving compartment of the vehicle, everything from the carrier compartment.
Very interesting. You are compartmentalizing the car. Driving compartment.
It's a not my lords. It's a
whatever. Yes. Then there may be an occupant compartment. Then there may be other compartment.
I will just take your lordship's one-line submission subject to your lordship's approval because I am a driver of a truck. The truck is owned by somebody else, and I am only directed to load certain materials. And these materials, the police says they're very well packed and 10 packs of 20 kgs or 25 kgs each, all in beautifully packed, wrapped up in polythenes. Then they load it on my carriage. That is what I have to drive there.
So being enamored by the beauty of the packing or wrapping, you will not flinch.
Probably, I would confess to that level. Probably that has happened with.
But you forget one thing. However beautifully you pack it, the smell that comes is not beautiful at all.
That might be beyond my knowledge. That I cannot say.
I have also knowledge because as
so much of cases you lordship have been pleased to deal with in those areas I have heard, and that definitely, my lords. But the only question is the police when finds. I was interested in anxious moments. For one line, the police could have caught hold of all these persons, and these gentlemen stayed put, and he surrendered before the police when police chased him. Others ran away into the thickness of the forest. So had this person known that yes, something is there and I must run and I must flee, when 3 others fled, he could have fled.
He must be a law-abiding citizen. Must be having must be having a great episode. But I think he must be having great respect for the rule of the law. The Constitution of the country.
Say so.
No, I didn't say it could be.
I was caught by
underlying argument. I somehow managed to see these.
That is one line, sir. But what I only got myself wiser from the statements the police they have given before lottery. So I can go beyond that. Nor was I there in the spot. I want to pray before lordship.
Only once you have been granted interim bail. Twice I am willing to grant you interim bail for some time. But there will be no further. There will be no further.
My subject to my conduct. Your lordship sees my conduct.
For everybody there is one order, sir.
Obvious.
Twice I will grant interim bail. Third time I will not. There are many regular practitioners in this court. They will testify to this fact. Twice I
believe the bench. Why should I go for the testification? I believe the bench. That's all. We have been taught that, and I still believe in a better language before this honorable court. If you want to grant me an interim bail, that will apply.
All right.
Because I can see my father in his last days. And still there is a time for repentance. I can repent before him.
Should I write that?
Yes, he can make an atonement at least.
Not like
crime is a crime. Well,
since custody since
8/8/2023.
8/8/2023. In connection with such case, it is alleged that the petitioner was driving a truck in which contraband ganja weighing 250 kgs. 250 no, 250 kgs were being transported. Stop. It is submitted by Sri S.S. Das, Foreign Counsel for the petitioner, that he was earlier granted interim bail by this court as per order passed on.
Your lordship may write it.
18/10/2023. Considering his considering the element of his father, though.
Yes.
Considering the illness of his father, it is submitted that. He surrendered to custody in time after expiry of the period of interim bail.
No, within the
He further submits that presently the condition of the petitioner's father has worsened and he is on his deathbed. The petitioner, being the son, wants to visit his father in his last days. Then State Counsel, while opposing the prayer for regular bail, however, fairly submits that considering the ground cited for release, the court may pass appropriate orders. I will not keep it pending. I will dispose of. I'll dispose of directly the court will to release you on interim bail. Considering the submissions and the materials on record, as also the ground on which the prayer for bail has been made, while not being inclined to grant regular bail, I feel persuaded to dispose of the bail application, directing the court below to release the petitioner on interim bail for a period of 2 months.
So 45. Grateful.
One word I may press for your lordship's approval. Your lordship decided not to grant interior bail, regular bail. Your lordship may act at this stage.
All right, at this stage.
I'm grateful for it.
There is no res judicata in bail appeals.
No, no reason, but that one. Right.
Yes. The commission of offense 302.
You have the charge sheet? You have the entire thing?
Yes.
Criteria now?
Yes.
All right. Go to.
My lord.
302, 201, 376, 2. Charge sheet.
Initially is lodged in FIR under section 302 and this PM report, it says that 376 and there is no motel and
that is not
that
there. And already with
police has been seized the certain evidence.
You give the postmortem report then?
Yes.
Postmortem report was
पेज लिखा है पेज लिखा है तले एकदम लास्ट तळକୁ पूरा पेज टा लिखा हां Yeah, next week of just
brutal murder, my lord. Yes,
my lord. And the last para number 4 in the postmortem written, it is written that there is no.
Oh, like you forget it. Let us forget
376 2 and
376. Let us rule it out.
My lord, again that is a police has circulated message through the mobile without filing any missing complaint. How did the this is a suspicious? How the police phone number they got it? So there is some pre-plan. So Manasi Patnaik was the elder daughter of this disease. She found in WhatsApp. Unless until add the phone number WhatsApp, it cannot be circulated the message. First, second, the 161 statement of the Basant Patnaik, who is the husband of the deceased. He has written that he was given the Pona in Meru Sankranti Pona deythila ye deythila lekhichhanti jota ki eyewitness ne se kemti janila Pona deythila. So third is disease police found certain material and he is arrested by after recognition of their daughter. He is arrested on 4th May and the police has seized the key, scooty and certain blood sample and those are no report is found. If it is a DNA report is matching with the what is the disease material, then it can be said, but there is no report. And the call report, what is the disease he was speaking with, all the phone number as in the name of this accused, the petitioner. And the police has seized 2 mobile phones from the accused. And definitely all this tower will be the same place only. And the disease one phone number has received. There is only the intimacy relation may be there. But he has not committed. But again, this is the petitioner at the age about 30 years. He cannot post, that is the disease age about 44 years. And the disease, if it is forced to this accused person for married, it is not possible. This person should be forced to the disease. It is not possible the 44 years age and in the younger age. There is other material, what are the no material is found by this police, only simply the suspicious maybe committed the murder. And he is the 30 years of age. That husband of this disease was going to the Priya battery working in Barampur from morning 7 a.m. to, and he was returning on 11 a.m. And this husband and this family member was residing at Gautami village, and this the accused person also residing at Gautami village. In Meru Sankranti on 14th April, they came, and 1st May, the disease is abandoned. Thereafter, that while going, that's Sonali Patnaik of the disease saw that one vehicle was written the DJ in front. After that, there is no material at all. Whether he is taken to the Sutari, how this is the who is the informant, he is the Sarpanch of the village. That's what there is some pre-plan made.
Correct. Since when are you in custody?
4th May.
The petitioner is in custody since 4/5/2023 in connection with such and such case. The FIR was an FIR was lodged stating that the dead body of a unknown female was lying near a culvert with injury marks on her body. Stop. In course of investigation, it came to light that the deceased was a married lady named Mamata Mahanti alias Sangupta Patnaik. She had been married to one Basanta Patnaik for the last 20 years. Stop. The couple was blessed with 2 daughters, aged about 18 years and 14 years. Taking advantage of the long absence of the husband of the deceased, the petitioner is said to have developed intimacy with her. The relationship continued for about 9 years. And it came to the knowledge of the husband of the deceased as well as her daughters. Stop. The deceased reportedly put pressure on the petitioner to marry her, which he refused. Stop. On the date of occurrence, the petitioner and the deceased talked over phone, and thereafter he came to village Samor Jhoda to meet the deceased. There was a quarrel between them, as the deceased again pressurized him for marriage. Thereafter, the deceased took her on her motorcycle, on his scooty to the spot of occurrence, and strangulated her with the help of her jewelry. He thereafter sat on her chest and pressed her neck and also gave several kick blows to her face and neck. Stop. It is submitted that there is no admissible evidence to show the complicity of the petitioner in the alleged occurrence and that he has been entangled only on suspicion. Stop. The offense under section 376 is also negated by the post-mortem report. And then State Counsel, on the other hand, has referred to the statements of the two daughters of the deceased who have spoken about the relationship. Stop. He further refers to the disclosure statement under section 27 of the Evidence Act of the petitioner. Stop. I have considered the rival submissions and have also gone through the materials available in the case diary, including the post-mortem report and the statements of the witnesses. Though there is no direct evidence, yet there are circumstances to link the petitioner with the alleged occurrence. Stop. The postmortem report is fully consistent with the prosecution story as regards the manner of assault. Stop. The fact that the petitioner and the deceased had a long relationship, including physical relationship, is well proved by the witnesses. Taking into consideration all the other facts, particularly the severity of the allegations, I am not inclined to allow the prayer for bail, which is therefore rejected. Yes. कितना रहा? कौन सी लिस्ट है ना? सदी